For page mentioning, page number 1, item 1 and 2. Page number 2, item number 3 to 8.
My lord, item number 7, if I may submit, my lord. Item number 7, my lord, we're filing an amendment application. My lord, 2 documents for which pleadings have been taken, but they're not annexed. Through RTA, we obtained it day before yesterday. But only within 7 days, my lord, if your lordship takes up the matter.
Can be the date 13, 14, 15th of September. 14th of September is already. The request of Mr.
My lord, on behalf of Mr. Somi Mishra, my lord.
The request of Mr. L.K. Maharana, and counsel is appealing on instruction of Mr. Somo Mr. and counsel for the appellant that the matter be listed on 26th of September 2023.
Page number 12, item number 9. Page number 13, item number 10 to 18. Page number 14, item 19 to 24.
I beg your pardon, my lord. Item 21, my lord. My lord, I don't want to press this writ petition, my lord. I become infructuous, my lord. This writ appeal.
21 or 22, Mr. Swai?
My lord is 21.
21, Mr. Mishra is the...
Sorry. 22, my lord, 22. Monoja ko bhi matter. Sorry, my lord. Extremely sorry, my lord.
Item 24, my lord.
Just a minute.
Just one.
WA 55-15-22. Mr. K. Swine and counsel looking for the appellant has submitted that this appeal became infructuous by flux of time. Stop. In view of the above statement, this appeal stand dismissed as infructuous. Yes.
Lord, item number 23, my lord. But the pleadings are complete, my lord. I pray for 2 weeks' time, my lord. This is regarding a virus. We are challenging the virus of Odisha development rules, my lord.
The 6th of September is already.
My lord. Oblex.
The request of Mr.
I will go ahead with Mr. S.K. Das.
You are not here.
My lord, I'm not there.
The request made for Mr. S.K. Das from counsel appealing for the petition that the matter be listed again on 26th of September 2023.
Item 24, my lord.
Yes.
Item 24. Maybe taken up after 4 weeks. I have to collect some papers. I have already appeared in 29 number of cases.
That's not done. 2016 matter, you filed for adjournment.
My lord, taken the consent.
Sorry, by consent you cannot the all matters.
My lord, a few days back,
Just will examine, you appear and the matter will be called out.
problem.
Page number 18, item 25 to 27. Page 19, item 28, 29 and 30. Page number 30, item 32 to 35. Page 31 to 4.
Item 34.
Yes.
So for some time to maybe able to file a regional.
34.
Yes, my lord.
When counter was filed?
Counter file also 9/1/2023.
And now you are asking for filing the rejoinder?
Regional.
Very unfortunate. It is also 2034.
34.
You are there on record?
Yes, my lord. A.K. Das.
The request of Mr. A.K. Das that counsel appealing for the petitioner, let the matter be listed on 1st of September 2023. In the meanwhile, the rejoinder shall immediately be filed, else no further accommodation will be made.
Page 31, item 36 to 39. Page 32, item 40 to 44. Page 33, item 45 to 47. Page 34, item 48 to 52. Page number 35, item 53 to 59. Page number 36, item 60 to 64.
My lord, 61, my lord. Item 61, I have filed the note of submissions and the note of citation.
All
I
right,
am for the respondent.
all right, let the matter be taken up. Okay.
My lord.
My lords, item number 64, last item. It may not reach today because of the heaviness of the cases. The dispute is more than 20 years old. I pray my lord to kindly call on this matter on any day at 2 p.m. so that it can be heard and disposed of the same day.
Let us see. 2 p.m. Let us see at 2 p.m.
Today.
My lord, today.
2 days.
Yes. Call out the matter pass in order, no?
My lord, other 3 items have been posted today. Other 3 items have been posted today at 2 p.m.
Oh, all right. There is don't worry for that. You just be there at 2 p.m. Let us see what happens in those cases. That is why I asking you.
I have already informed to video counsel, Mr.
Yes.
Writ appeal filed in the month of April 2023. I pay next week, because the other side is initiated.
But it has not been listed. Have you taken it?
There is a defect, my lord, which in the meantime I cure that defect.
In the next week.
Two CM appeals for restoration of writ petition and writ appeal.
File it. This will automatically come in the list.
My lord, I make pardon, my lord. One fresh writ appeal filed by state. So,
Next week.
any day next. My lord, these are 4 anticipatory bail applications, your lordship. The honorable assigned bench recused from hearing. So unless your lordship directs.
Mentioned before the Deputy Registrar Judicial, they are given instruction. They place this, you mentioned memo administration, the administrative side.
My lord,
Don't mention these matters in the court.
my lord.
Yes.
Pardon, if I can mention, my lord, regarding juvenile matters, matter to the assigned bench which needs the legal lordship. Where the juvenile, in the meantime,
It has been.
Regular bench.
What is the difference between the regular bench and assigned bench?
my lord, the regular bench which is assigned to this matter, but the matter, he directed the matter to be placed before the bench which give them the bail order, the appropriate,
In this case, my lord,
appropriate bench.
this petitioner is juvenile matter. In the meantime, principal religion bail by the another court matter. And this matter not assigned this bail. That's why this bench was your lordship for assignment for put up this matter.
Just before the Minister Judicial.
I mentioned my your lordship directed on Monday, my lord. Monday I have mentioned before the deputy registrar. Tomorrow also I have mentioned before the deputy registrar. Till now. Again, father of the petitioner expired.
According to mention, your lordship, matter relating to recovery of minor child, your lordship.
The next Monday. Have you given the copy of the notice to the State Council?
Lordship?
That you have copy of the petition you have served on the
Yes,
State Council.
yes.
All right.
May I call the list? Supplementary list, fresh submission item number 1.
Item 1, my lord, I pray for Monday, only Monday. Today is some difficulties with that, only Monday.
Number 1.
Yes, sir.
It may not be possible on Monday. Give a date.
Yesterday.
That I think there is some urgency in there. What is the date? You are on record? You are mentioning item number 1.
Yes, my lord, some difficulties due to this with
I
the.
don't know whether you are on record. I am asking you. You are Miss Armapatra.
Yes, my lord.
The request of Miss Armapatra and counsel that the matter be listed again on 23rd of August 2023.
Your lordship is fixing it 23rd.
3rd of August.
Item number 2. In Your lordship, there are 2 IH, one for dispensing with, another for limitation. That your lordship, grant me sometime that I will file certified copy that on my dispensing with petition.
So you could not file the certified copy?
No, I have filed the Xerox copy. So I'll file it to your lordship.
Why are you not filing the certified copy?
Because at the time of filing, what has happened, well, we are applying it a general application, so it takes some time. That limitation is there, but we are filing with the Xerox copies.
No, as you are preparing the appeal after the expiry of limitation, this kind of things happen. Because if within the time of limitation you file, you know that period you will get on the court. Anyway, let us see. The 2IA, all the appeals are the similar situation.
Similar, common judgment.
All right, no, this IA and other thing.
So same.
All right. IA 3641, similar IA is all the weekend proceeding filed. This is an application by the appellant in WA number 1389 of 2023, seeking dispensation of filing of the certified copy in field order dated 27/7/2022, passed in WPC number 34247 of 2020. Mr. M.K. Kunti, on additional government advocate, appear for the applicant, has stated that though the appellant has applied for the certified copy that has not been received as yet, but they are under the pressing circumstances of filing of the intercourt appeal against the state. So, having regard to the fact that they have filed one downloaded copy of the said order dated 27/7/2022, we grant the dispensation from the form filing of the certified copy of the included order, but the appellant shall file the certified copy when they will receive a certified copy from this court. So accordingly, this application in terms of the above is disposed of. Next is IA.
There is a limitation of 305 days.
I 3642. Mr. M.K. Kuntia appearing for the appellant. This is an application for continued delay, which according to the stamp report, 366 days in filing the appeal from the order dated 27/7/2022, passed by the legislatures in WPC number 34247 of 2020. Issue notice as to why the aforementioned delay shall not be condoned or any other order or order shall not be passed. Notice is made returnable on 29th of September 2023. The steps for service of notice on the sole opposite party shall be taken by the applicant within 3 working days from today.
3 working days.
3 working days from today, registered post rate 80. All right. With similar orders in all the matters?
Yes, ma'am.
Don't press for the stay now. No, there is no contempt, I find this. No, whenever the contempt petition will file, then you trace this
Yes, ma'am.
petition, not now. Okay. Similar orders in all the matters. Just only check with the assembly now, days of delay. Huh? Yes, call 3.
Item number 3. Last token also directed to high English classification of annexure 3. There is a representation. Already I have already filed a English translation, my lord.
All right. Already, Mr. Mohanty,
Yes, my lord, I am appealing.
certain of the financial irregularities, the allegations, we direct the collector to inquire into. And if something the allegations is found to, they shall take action at law.
My lord, may I, if your lordship will permit me, these type of allegations are ordinarily to be taken by cognizance by the Lokayukta, because this is financial irregularity against some government officials, and he is a public person. So
He can go and ask.
he can approach Lokayukta. That is the correct forum. And in this light, this honorable court has passed many orders and disposed of the cases. So
You go to Lokayu.
My lord, time class annexure 4, my lord. The opposite partner 1.
I don't know.
Letter to inquire the matter on dated 24, 1274, my lord.
Yes.
Or issue a letter to inquire the matter, but till today they have not inquired the matter. Thereafter, 75, annexure 5 also, district Panchayat officer also issue a letter to the BDO, my lord.
I just, they asked this additional secretary who is conducting the inquiry to complete that inquiry.
My lord, I think
Petitioner-
additional secretary has asked the collector to furnish the views.
That is why that also be there, and I will give liberty to the petitioner. If they want to approach the Lokayuk, they can also approach the Lokayuk.
In that light, the case can be disposed.
You are Mr. Sethi.
My lord.
Heard Mr. Dharmendra Sethi and counsel appearing for the petitioner. And also heard Mr. D.K. Mohanty Leonard counsel is appearing for the opposite parties number 1, 2, 3, 4, and 5. Stuff. Yes, we are not going to issue any adverse order against the opposite party number 6. We have taken up the matter for disposal. As agreed by the council who are before us. Stop. By means of this public interest litigation, the petitioner, who is a public spirited person, has asked this court to conduct an inquiry regarding the specific audit of accounts of Anji Grama Panchayat for the year 2017-18, 2021-2022 in view of the content of the interdepartmental communication dated 6/6/2023 Annexure 5 to the writ petition. Stop. The interdepartmental communication reflects on some allegations received by the district panchayat officer on some financial irregularities in the Anji Gram Panchayat. Stop. That apart, it has been requested, it has been asked before this that the opposite party number 4 the block development officer, the commandant, the opposite party number 4 opposite party number 3, the collector come district magistrate Balasore, the commandant. To dispose of the representation dated 11/4/2023, annexure 3 to the writ petition. Mr. D.K. Mohanty, current counsel appearing for the respondents, the opposite parties number 1 to 5, has stated that the petitioner as a citizen would have the Lokayukt on the allegation of the financial irregularities in a Gram Panchayat. Stop.
Financial irregularity, if any. Financial.
Alleged financial.
Alleged financial.
Having heard the counsel for the parties, we are of the view that having perused the communication dated 6/6/2023, annexure 5 to the writ petition, we are of the view that the opposite party number 3 is required to conduct an independent inquiry on the allegations made in the representation dated 11/4/2023. After the inquiry is complete, a copy of that inquiry be communicated to the petitioner. Such inquiry shall be completed within 4 weeks from the.
My lord, kindly 8 weeks, because this is.
Sorry, 8 weeks. I missed 2 months.
2 months. Yes.
8 weeks from the date of receipt of the
Yes.
Copy of the order of the receipt of a certified copy of this order. The petitioner shall file the certified copy of the order to the collector cum district magistrate.
Balasore.
Balasore. Stop. It will be open to the petitioner if he is aggrieved by any decision of the collector to approach the Lokayukt state of Orissa.
My lord, one thing I want to point out is the collector, while conducting the inquiry, should hear this opposite, private opposite, because
all right,
allegations are against
we
you.
also mentioned that
Private opposite, but
while
not 6.
conducting the inquiry, the collector cum district magistrate shall give opportunity of hearing
Yes,
to opposite party number 5.
6, my lord.
6, sorry, 6.
Tapan Kumar Rao.
Opposite party number 6. In terms of the disposed of. Next.
Item number 4.
This is a matter of PA. The petitioners are the villager village law. Opening of 4 to 7. have forcibly occupied
This is
the
the same type of case yesterday your lordship has in Goppo Tahsil. The government road is encroached by, and your lordship has directed the Tahsildar Goppo to, a similar order your lordship has passed yesterday 2 orders. It is same kind as I,
So we are directing the Tahsildar to make an inquiry.
and dispose of the representation.
Yes. You are Mr. Palai?
my lord.
Heard Mr. Suryakanta Palai, Learned Counsel appearing for the petitioner. And also heard Mr. D.K. Mohanty, Learned Counsel appearing for the opposite parties, number 1, 2, and 3. Stop. Since no adverse order is being passed by us against the opposite parties, number 4, 5, 6, and 7, we are not issuing any notice. Even though the matter has been taken up for disposal. So by means of this public interest litigation, the petitioner has asked this court to protect the community land within Rastha, Potito, and Grammo Jungle recorded under Khal Khata number 325, plot Hal Khata number 325, plot number 310, 311, and 341, comma Khata number 327, comma plot number 309 and 342, and Khata number 328, plot number 146 and 1461 of Moja Lunahara by evicting the unauthorized encroachers from the said land within a stipulated time. Stop. It has been stated that some persons have occupied, encroached unauthorizedly the above described land, but there is no action from the opposite parties number 1, 2, and 3 in order to evict those encroachers from the community lands, plus the government land. Stop. The petitioners have filed the one representation to the collector Puri for taking the appropriate action.
Tahsildar Gop, he has also, because he is the Tahsildar Gop is at page 26, Annex 2.
It is not to the Tahsildar.
It is page 26 is addressed to the Tahsildar Goppo. In Odia it is named.
But you see this index, it is stated addressed to the collector Puri.
That is page 23.
You are referring to Annex 3.
Annex 2 series, my lord.
All right, there is another.
Page 26 is addressed to the Tahsildar Gop. Same allegation.
Representation addressed to the collector Puri and Tahsildar Gopo.
Annex 2 series.
Gopo.
My lord.
Goppo. Yes.
All right. By demanding action from those authorities. Stop. What is the RI report says? They are in occupation. That is the
Constructing houses.
from the report of the revenue inspector dated 27/2023, annexure 3 to the petition. It also transpires that some unauthorized persons are encroaching the community lands as the government land as described above. So Mr. Mohanty Learned, additional government advocate, has stated that the collector Gopo be directed to
Tahsildar Goppo.
Tahsildar Gopo.
Be directed to examine the representation.
To inquire into the allegations and take the appropriate action as required under law. Stop. Having appreciated the rival contentions, having appreciated the contentions of the party, council of the parties, we direct the Tahsildar Gopo, District Puri, to conduct an inquiry in respect of the allegations as made in the representation petition and take appropriate action within a period of 8 weeks from the
After
date,
giving opportunity of a hearing to the private.
8 weeks from the date of receipt of the certified copy from the petitioner's stuff. It may be mentioned that before taking any action adverse to any individual, those who has been alleged to have been encroaching the above land, and after giving an opportunity of hearing to the persons such and such, in terms of above, this petition still is disposed of.
Item number 5.
That the opposite party number 2 has died in the mean period, though exact date was not
Okay,
with me.
all right, brother. Do you have any information?
No, I don't have any.
All right, you just get confirmation, but would you file any objection because there is a delay of 82 days?
I have not filed. In fact, I have
Would
not
like to
filed.
file?
Yes.
All right. In the request of Mr. S.C. Mahapatra and Senior Counsel, listed by you, Mr. Mahapatra also?
Yes, Mahapatra.
Listed by Mr. S. Mahapatra. Let me just this limitation petitions. Let this petition be listed again on 26th of September. In the meanwhile, objection, if any, be filed by the opposite party, no further recommendation will be made. Mr. J. Kotukil and additional government advocate is appeared for the applicant. All right. In the meanwhile, just confirm regarding death of two through the police station, Mr. Kotukil.
Yes.
Statement.
My lord, your lordship, subject to the date or
All right.
only submitted that they inform.
All right. Just below, Mr. Mahapatra and Senior Counsel has reported death of the opposite party number 2, but he has fairly submitted that he doesn't have any concrete information regarding the date of death. All right. What is the name? You could give the name of the police about check up his title. Yes.
Item number 8.
Suggested, my lord.
No, he'll be already stating because since the date loss.
Item 8.
Item 8. Mr. Rao is appearing in some cases. I am also appearing for the board, for the appellant. In all these cases, you also issued notice and passed an interim order. And there are some defects which we have already made. But the condemnation delay, but we found that the 15 days of you also had issued notice on the condemnation delay. In some cases, 15 days, in some cases, 16 days, and in some cases, 22 days delays. So if your lordship will fix up a date and subject to what my one friends are appearing, we are ready to serve a copy of the already sir.
One copy each we have, sir.
No, not in all the cases there is the copy, and all the cases there is a delay. Delay has not been condoned, but they got an interim order.
No,
And it's a case of pension.
No, all right, wait. Don't add further tensions to the cases. Just can the delay be condoned because it's a very small.
Condone the delay, what's short date? Meantime, 3 petitions, respondents have been died of my client, Lord. I have also supplied copy, that certificate, Mr. Rao, to substitution.
We'll take steps also.
In which matter, just mention the case number.
Yes,
Your matter. No, your case number.
Document number 1492 of 22, That is in the second page of
Page 4.
149.
1491 of 22. 81, sir, 1481.
So what is the series 7, 8?
Abdul,
7 and 8 only, Mr. Das?
22.
The matter is 7 and 8.
8, it's not 7 is not the matter. 8 is the matter.
7 already.
8
Oh,
years.
Only 8 months.
Okay.
But total number 37 cases have been listed.
1565 of it.
As I have appearing the cases, the lead case in the single bench was that second case in the list, Madhusudan Naik. Unfortunately, my senior friend has not solved me the copy of that delay conversion petition. But he is submitting delay will be condoned.
No,
That is the unfortunate part. I'm saying. My friend, this is the only copy you saw.
all right, you just serve the.
And all the cases are octogenarian.
My friend,
Two rounds of earlier litigation has been implemented. Up to Supreme Court, the matter has been carried. This is the fact. Limitation. You are hesitate to supply the copy of the limitation. Is it a matter of course that all the delay will be condoned?
No, I haven't sorry.
You got an interim order.
Sir, you shouting?
My lord,
Why are you shouting?
not shouting, this is my voice. I heard it. This is my normal voice. And my lord has supplied me the mic. That's the problem.
So then lower your voice. You
It's
don't
not
have to shout
shouting.
because the mic
I'm
is
not
there.
in that way.
No, Mr. Das, I'm telling you, are you serious about raising objection about the limitation?
I don't know in each case.
If you say that we will not pass any order, because you are saying that is a 15, 17, 18.
I am saying, they are saying.
You do not know anything.
Because they have not submitted the copy.
All right, sir.
In only one copy. Like this, they have given you only one
All
copy.
right, the argument is whoever is appearing. This is
Not that, my lord. Time now. They have started time.
No, this is everybody's concern. It was also the concern of Mr. Das also.
One of my client is 98 years. He is alive.
What you do, still ready for program.
And that is the reason, Mr. Das, I was planning if the delay is condoned today, I will fix the matter on 31st of August for the disposal. But since you will be examining the days and the nature of delay, so you cannot pass. Mr. Bashish,
Had I been given a copy, I could have seen the grounds.
all right, we are not objecting. It will come on 31st August again.
On the same date, while if that is, there is nothing in that petition, my lord, may condone the delay and hearing on merit. I am ready.
Mr. Rao, you are appearing for in 1492. Your case is 1492.
1483.
No, you mentioned the earlier the 1492.
149.
Which the respondent has died.
That date.
Ashish Bishwas died.
Date. On Abdul Hanan, Ashish Vishwas and Kartik Mati.
81492.
He is saying 3 persons died, 1481,
Just
1492.
no, this 1492 is only Ashish Bishwas.
Ashish Biswas.
And
And any other matter?
so that 81 is.
Yes, he is saying that Kartik Chandra Mahanti in 1481 died. That is in the first page.
You were saying, Mr. Das? 3.
1565.
1565.
The next page. 1565.
There also the respondent is passed away.
Yes, ma'am.
65. 6. The last almost now. Abdul Hanan Khan. Fifteen days.
Let's start with 1565. So this Abdul Hanan Khan has also passed away.
Abdul Hanan Khan.
Well, I have a suggestion.
You have appeared.
Well, I have a suggestion. If the landfill was actually to 31st to be disposed of, let me also undertake to apply for those incentives. So
I have already received Honorable because they are not parties, I cannot.
No, just I am reporting death only.
Yes, my lord.
Mr. Sisi Das and
May I be permitted to file a petition, my lord, to implement me back?
in the meanwhile,
I'll file a petition.
already. Our council has informed this court. That the respondent number one, namely Abdul Hanan Khan, has passed away in the tendency. Mr. Das, when Francis leaves of the court to file an appropriate application for substitution. Such applications will be filed by 25th of August, 2023. Let the matter be listed on 31st of August, 2023. Similarly, we'll just check out the respondent's name in 1490, same order, same council, in 1481. Right. And just below, you just write it down, Mr. S.S. Rao, on a senior counsel, assisted by Mr. E. Hawk. And counsel appears for the appellant. Both the appeal, all the counsel's name has come in. All right.
In 1534, Mr. Rao, you have not taken steps for limitation. Mr. Das is appearing.
yes.
That is my concern.
Serve a copy to
Sir, you are not aware. You are saying copy is not answered. Only if he files, he will serve.
Yes, sir, one copy.
For the
In fact, my friend said that give me only one copy. I didn't want them to say.
also, just you part.
You got that is lie. I never said that.
Mr. Bharat, it is been stated by Mr. S.K. Das, counsel appearing for the respondent of one, that he has not received a copy of the application. Stop. We request Mr. A.C. Hawk and counsel who is appearing for the appellant to supply a copy of the petition for condoning the delay in the course of the day in all the matters.
Yes.
Let the matter be listed on 31st of August, 2023. Meanwhile, if the said respondent's opposite party intends to file any objection, such objection shall be invariably filed, as there shall be no further accommodation for the purpose. See, all the other matters listed on such and such date. Where you have not taken step, we are not indicating you take steps. Otherwise, we will dismiss it being barred by limitation. I will take yes.
And Mr. Rao, 1486, just check that.
And look at the council. SSO is everywhere. And Mr. Rao, you are appearing which
Council not taken note of.
item number
Recent
2.
complaint.
I'm appealing WPC, appeal number 1498 of 2022. The second page, last one.
Mr. Rao, you are there, Mr. Biswal? My boss is not there. Who is there? Who is this?
Mr. Hogg is also there.
Mr. Hawk. Yes.
Mr. Mishra is also there.
In all these cases, I am appealing for a statement.
Mr. Kumthia for the suspend of the state opposite party. I think you are responding number 2. Responding number 2 in all the matters.
I am appearing in item number 5. A copy me, I mean, if you want copy.
5.
Copy of
8 serial 5, serial 5.
So, but we know that.
WA 1484 of 2022.
What is your, you want a memorandum, a copy of the memorandum?
I am favored with one.
He's
I will do it.
1484.
All right, supply the copies.
I will.
So this is, I think the Mr. Should be following this way. Who is assisting you in this matter?
Miss Pradhan.
Yes, you see. Stop. We are planning to hear the matter on 31st of August.
Very good.
Mr. Rao, same problem 1486 and 1481 where 1481 somebody has died. There also you just check
Yes,
the noting.
So the similar orders regarding death will be passed in WO format to 2022. 1481 or 2022. Is the same way.
On the 9th of the same.
All right.
Grateful. Item number 9, if 3 more matters are left out, my lord, I will give the numbers. 3 more matters are there. I will
The list. But also supply the limitation.
I will also
application. It's everything.
Item 9. My lord, in item number 9. Mr. Mishra, the learned senior attorney appeared.
Mr. Mishra is not.
But item 9 actually there are some defects. I think that has to be ignored, I think, as it appears. And this synopsis comprehensive note, but I have prepared a small note with regard to the question of law that arises for consideration. You also kindly see that.
Mr. Barik, you are appearing for the.
Mr. Barik, I filed
being assisted by Mr. Barik.
Yes, right. We are together. The counsel, I think he told me.
I haven't received the notice, but I have instruction to appear and file VNAMA today. He is coming with the VNAMA. Till now, I have not filed the Vakalatnama, but I'll be filing in the course of the day, my lord, for all the opposite parties.
So, are you prepared?
No, I haven't seen the brief, my lord. The notice has not gone, my lord. Notice has not been issued.
That is the reason why I am giving the legal points for
All right.
He has not seen the client, so how can we see the brief?
Yes, my lord, the notices could not be issued because the postal requisites are filed little late. So therefore, notice, and that is also noting because postal requisites are filed little.
No, because that is the reason he has not.
Yes, ma'am.
appearing as no.
You just memorandum of appeal. And also the question of substantial question of law that you have formulated, you supply a copy to that.
I'll start copy.
Let the matter can be fixed.
No, go to that again. Go to.
And Mr. SP Mishra, let us senior counsel, case to be Mr. Barik. Mr. Barik, counsel to the appellate. This is the matter on, can it be on 14th of September? 14th of September 2023. Mr. Vigyan Sharma and counsel has appeared for the sole respondent on instruction. We direct the counsel with the appellants to supply the copy of memorandum of appeal as they have failed to take steps.
In fact, my lord, in one case only notice are issued.
Is issued and
For one case. Not that is 1434 of 2020.
not 3 cases.
We'll take an attempt to hear the matter at this stage finally. Keep it under control. The other matter also similar.
Same. All 4.
Same order.
But different insurances at different places.
All right. So the 4 matters similar order is being passed. 14th September, all the matters.
Item 10.
My lord, in this matter, private opposite parties are 5 to 11.
Yes.
Inadvertently, probably my lords have only issued to the opposite party, not 5. Therefore, the private opposite parties 6 to 11 are to be noticed.
All right. No notice has been issued as yet.
The second page inadvertently has not been.
Now, Mr. Roth, just I am concerned whether any notice was issued.
To opposite party number 5 only.
Okay. And what?
6 to 11 are the private opposite parties. Those inscriptions are in the next page. Probably that has escaped the notice of my lords.
Right. And who are representing 1 to 4, Mr. Behra?
My lord, state.
All right. By the order dated 23/3/2023, this court issued notice on the respondents number 1 to 5. It appears that due to inadvertence, notice has not been issued on respondents number 6 to 11 of Mr. Jayanto Kumar Roth from the senior counsel, who is esteemed Mr. Amit Das.
Amit Kumar Das.
Assisted by Mr. Amit Kumar Das, learned counsel, has pointed out this omission stuff. In the order dated 23/3/2023, no reason has been recorded for not issuing notice to those respondents. Having regard to the nature of the challenges raised in the appeal, you know, the view that we should issue notice to the respondents number 6 to 11. Accordingly, we issue notice. So, Mr. Das, learned counsel, the appellant shall take steps for service of notice on the respondents number 6 to 11 by registered post with AD within 3 working days. Notice is made returnable on 21st of September 2023. Mr. K. Vera, learned additional standing counsel, has appeared for the opposition respondents number 1 to 4. It appears from the registry's note dated 17/8. No, sorry, dated 11/8/2023 that the appellant does not file the requisite for service of notice on the opposite party number 5.
I'll take along with that,
Such requisite shall also be filed for service of notice on the opposite party number 5 within 3 working days, registered post with AD. But really should not be.
This appeal has been filed by the state. There is a delay of 264 days. IA number 1345/2023. That is at flag A.
This is condonation petition.
Yes, ma'am.
Mr. P.K. Moduli, additional government advocate, appearing to the applicant. This is an application for condonation of delay of 264 days in filing the intercourt appeal from the judgment in order dated 27/5/2020, passed by the learned single judge in WPC number 13354 of 2022. So, issue notice as to why the aforementioned delay shall not be condoned or any other orders, or orders shall not be filed in the circumstances of the case. Notice is made returnable on 21st of September 2023. Steps for service on the opposite party shall be taken by the registered post with AD within 3 working days from today. Yes.
Item 12.
On behalf of Mr. S. Rao, I am permitted to pledge the matter.
You are appealing for Mr. Raut. A. Raut.
Yes, my lord. On behalf of Mr. A. Rao. My lord, delay is 69 days. Condemnation petition.
All right.
All the opposite party, they are government, my lord.
Yes.
I have no objections.
If the delay is condoned,
Your Lordship.
so your name, please.
SUBHASIS.
Heard Mr. SUBHASIS and counsel. Appearing on behalf of Mr. Shaktidhar Mishra.
Yes, ma'am.
And counsel to the applicant in IA. There is an application for condoning the delay of 69 days in preferring the intercourt appeal from the judgment in order dated 16/12/2022 passed by the single judge in WPC OSC number 3713 of 2013. Stop. Mr. Arnab Behra, learned counsel appearing for the opposite parties, has at the outset submitted that those opposite parties will not oppose the prayer for condonation of delay. Stop. Be that as it may, having produced the causes so assigned for by explaining the delay, and also on taking note of the concession given by Mr. Behra, an additional government advocate, we condone the said delay. Stop. In the result, this application is allowed and disposed of. Are you ready for admission now? Are you ready for admission now? Next in the in view of the order passed today in I number such and such 1536 of 2023. Let the appeal be listed on 26th of September. No, you are telling 26th September 2023.
Item 13.
I beg apology to interrupt in between, Your Lordship. In item 8, there are interim orders. Mr. Rautra has forgot to mention that, Your Lordship.
Item
8, there are interim orders, Your Lordship. That has to be continued.
That's a writ appeal.
Yes, Your Lordship.
In every case, there is a.
Yes, Your Lordship.
Just in all the interim order. If any passed earlier, shall continue till the next date.
I am grateful for Your Lordship's mercy.
13.
Appeal file delay condon maybe 33 days, Your Lordship.
No notice was issued earlier?
No, Your Lordship.
You have removed the defects?
Your Lordship.
In I 1835 of 2023. You are Miss Naik.
Your Lordship, Susmita Naik.
Are you appearing in person?
Your Lordship.
You are not supposed to wear the lawyer's band and gown. All right. That is Susmita Naik. The applicant appears in person. There is an application as Section 5 of the Limitation Act for condoning the delay of 17 days in preferring the intercourt appeal from the order dated 3/2/2023, filed by the London Single Judge in WPC number 350971 of 2023. Issue notice as to why the aforementioned delay shall not be condoned, or any other orders or orders shall not be passed in the circumstances of the case. Notice is made returnable on 27th of September 2023. Steps for service of notice on the opposite party shall be taken by the applicant by registered post with AD within 3 working days from today. Initial defects have been removed. Have you removed the defects? All right. But there is no reflection in the notice.
Yeah.
You just check up with the registry. All right. Ms. Shashmita Naik, the applicant has undertaken before this court that if any defect is still there, she will take steps for removing those defects. Okay. Call next item.
Item 14.
Oh, based on.
Yes.
Exactly. There is a delay of 139 days. My learned friend has appeared. I'm appealed for the caveat or my opposite party, copy not served on me, but I file objection to the condemnation of delay itself. Yes,
So,
my
just an issue. No notice was issued earlier.
no, my no, my
In I number 2469 of 2023. The same way earlier order delay is of Mr. M.K. Kuntial, an additional government advocate appearing to the applicant. Then this is an application of a section for the Limitation Act for condoning the delay of $17 days, I think. No. What is the date? The stamp reporter has not reflected anything. Yes.
139 days check approach on my.
Oh, you have not filed a certified copy also in this case.
I filed a dispensing with person.
Okay. Can we dispense with the filing of the certificate?
I have not.
But I think you have calculated the number of days that is delay.
Yes, on that date of filing on that.
Have you made any amendment there in your application?
Is that perhaps
because here I find a practice in this condemnation petition. Nobody cares even what is the date of the judgment.
Yes, but that has been reflected in this petition. So I said 139 days.
All right, there is the stuff. Since Mr. Sir, what's your name?
J.K. Khuntiya. J.K. Khuntiya. 30 days.
J.K. Kuntial and it council
17/9.
appeared for the
27/9 covered till 27/10.
The sole opposite party. No
Filed on 9/5.
called for, but Mr. Kuntial and it government additional government advocate shall supply a copy of the application seeking condemnation to Mr. Kuntial in the course of the day. So let the matter be already listed date has not been given. Give on 21st of September. Meanwhile, the opposite party shall invariably file the objection if any. Stop. The other matter is this is 2468 of 2023. Heard Mr. M.K. Kuntial and counsel appearing for the appellant applicant. This is an application for dispensing with the filing of certified copy of the order dated
Stop.
9/2022.
The paragraph 5 of that IA.
Number 25383 of 2022. So Mr. Kuntial and additional government advocate has stated that because of the urgency of the filing of the appeal, they could not wait for collecting the certified copy. However, it has been pointed out that a downloaded copy of the said order has been filed along with the memorandum of appeal. So we dispense with the filing of the certified copy on condition that the applicant shall file the certified copy within a short while to comply the requirement of the rules. So accordingly, this petition stands disposed of. Already I just disposed of. Okay.
Item 15. In item 15, there is also delay of 312 days.
But stamp report says 284 days. Here also an application for
dispensing.
No, you have not filed any application for dispensing.
No.
There is a stay application.
There is a stay application.
IA 2848 of 2023. There is an application and Section 5 Limitation Act for condoning the delay perhaps of
Scan copy or certificate copy.
delay of 284 days in filing the intercourt appeal from the order dated 11/7/2022 passed by the 11th single judge in WPC number 14813 of 2022. Stop. Issue notice as to why the aforementioned delay shall not be condoned or any other order or order shall not be passed in the context of the case. Notice is made returnable on 26th of September 2023. Steps for service of notice on the opposite parties will be taken by the applicant within 3 working days from today by registered post to AD. All right.
Item 16, may I pray this matter may be fixed to 14th September because similar matters are fixed to 14th September.
14th September. All right. 14th. Make it 14th September. 16.
Item 16. In the case, there is a delay of 44 days, my lords.
All right. In IA 3507, is an application same way. Only Mr. Dayanand Mahapatra has appeared. This change, make the necessary change and delay is of same date. It will be on 26th, returnable date. The rest of the order is same. Delay is of 44 days according to the stamp report. 44 days delay. 26th of September is returnable date. Take stay within 3 working days.
I will take step minutes. Only my payment is a small date because of the fact that my service has been terminated by virtue of the order of the direction of the Honorable High Court. I'm working with the assistant professor.
You know that unless the matter is heard.
I understood minutes because the limitation is there.
Yeah.
I take minutes through speed post and changing minutes or special messenger. It's thought that it can be fixed.
26 September, before that, it's very difficult to give dates.
Fact means minutes. This way, humble we are minutes. Taking into consideration of the fact that minutes service has been fixed.
14th. Just one matter. Oh, 12, no? Make it 12. State not by registered but by speed post. By speed post. Within by tomorrow. Taken not by tomorrow. All right.
Item 17. There is a delay of 279 days. And I also filed an application for dispensing it.
Take down this in IA 4733 of 2023. This is an application for dispensing with filing of the certified copy of the input order dated 22/9/2022. As with a single judge in WPC number 20779 of 2023. There is an earlier, there was a dispensation. Same way, this disposal by matter. Then, in view of the order passed today in IA number 4723 of 2023. It is ordered in IA 4734, condonation by Mr. M.K. Contia. Additional government. This is an same type, not template. It is an application of decision filed with the Limitation Act for condoning the delay of 279 days in filing the intercourt appeal from the order dated 22/9/2022. Possibly the learned single judge in WPC number 20791 of 2022. Issue notice to why the same thing. Notice is made returnable on 21st of September 2023. 21st September. Steps for service of notice on the sole opposite party shall be taken by the applicant within 3 working days by listed post AD. Next.
Item 18.
This case, my lord, I am the petitioner.
Yes.
On 27th March 2023, my lord, the state was directed to take instruction and file counter.
We have already filed counter. Copy. Yesterday I wanted to serve copy on him. He said that I am not present. I will take it tomorrow in court. I am just serving the copy there.
Take the copy. Mr. Liki Mohanty, the additional government advocate, has stated that the opposite parties have filed the counter affidavit
on behalf of the GA department.
Only one person? You are not for the 2 also?
BMC is there.
My lord,
No,
I'm appearing for BMC.
All right. 1 and 2. The counter affidavit is filed by 1 and 2.
1 and 2, madam.
Yes.
This is a GA department and the collector and district magistrate both.
GA department is government has filed.
All right. We found the affidavit
1 and 2.
for the opposite. No, he says only 1.
Okay.
For the opposite party number 1. So, but the copy has not been served to the Mr. Brahmananda Tripathi Learned Council who appears for the petitioner. But Mr. Mohanty, Learned Indian Government Advocate, has served the copy of the counter affidavit in court. Stop. Would you like to file any reply?
Honestly, we have no role to play in this, but
All right.
I am appearing.
And the same party, Learned Council, appearing for the opposite parties number 3 and 4.
I am appearing for opposition of 4, that is General Manager Watco.
All right.
BMC is only 3
So
months.
I will file counter to this.
Appearing for the opposite party number 3 has submitted that opposite party number 3 doesn't have a primary role. So what the grievances enumerated in this writ petition is concerned. So Mr. P.K. Bhuya, Learned Council, has appeared for the opposite party number 4 and praised for short accommodation for filing the counter affidavit. Let the matter be listed on 26th of September 2023. Meanwhile, the opposite party number 4 may file their counter affidavit. It is made absolutely clear no further accommodation will not be made. But the criminal CRPC doesn't contain it. All right, you just will take up the matter in
23 years. Because the court below has kept the proceeding by 28, by issuing these orders.
Why don't you come prepared then?
No, so your worship is
You are Mr. Behra.
no, SS General.
At the request of Mr. SS General and Counsel appearing for the appellant, let the matter be listed on 23rd of August 2023
Is appearing in person.
for hearing on maintainability of this appeal. You are appearing in person.
Person.
Your worship?
You are appearing in person.
Yes.
Your worship?
You are the appellant.
Yes.
Your worship?
When you are appearing in person, don't wear the lawyer's robe, please.
Your worship?
It confuses the court.
Your worship?
So this is just Mr. S.S. Jena, the Sudhanshu Shekhar Jena, the appellant appears in person and urging for a short accommodation to make his submission on maintainability of the appeal. Let the appeal be listed on 23rd August 2023. No further accommodation will be provided by this court. If anybody is appearing for the in this appeal, you have not filed a certified copy?
Your worship, filed
The stamp
the petition for interim appeal for dispensing it, the circular copy. If court wanted, then next.
What is the rule to file the certificate?
I have filed in, but not at the time of filing, not available with me. That's why.
I understand, but he has not also filed the certificate. Do you have any other LPA?
Yeah, Lordship.
Do you have another LPA before this court?
No, Lordship.
Mr. Jenna, please look at your certificate.
Yeah, Lordship.
LPA number 3 of 2019.
So another order, Your Lordship. Another order. Against a single bench, another order, not a particular order. I would like to clarify by 20.
Just I am raising the registry has raised the what objection they have raised. I am reading it for your benefit. As per the report of the stamp reporter, the LPA may not lie to this honorable court as the order passed in criminal miscase is challenged. So keep it in consideration that there is no concept of LPA in criminal matter.
Your lordship, stamp report has reported, if the law permit the court to do.
That is why I am asking you for your assistance only, that you keep it that in mind. I raised.
Stamp report has reported.
All right, the next time when you are appearing person, please don't wear the and gown.
Yes,
Black coat you have no problem, yes. This is only to make the distinction between the person who is appearing in individual capacity and those are represented by the lawyer.
Your lordship, I would like to say only decision of this Honorable High Court, single bench, there is no law to, there is no bar in law to argue the matter if the matter in person.
We have no difficulty. We are not stating that as in the personal capacity you cannot argue before this court. We are saying don't wear the lawyer's robe.
Your lordship.
That is everywhere this discipline is maintained. The robe you can wear only when you are appearing in the court as a counsel, not otherwise.
Your lordship.
All right. Yes, next matter.
Item 20.
This is separate order. We made the statement there.
Item number 20. Item 20, my lord. So I am appearing for the information. Respondent 1, my lord. What has happened in this lordship? ABCL inadvertently this copy was served to Mr. D.P. Dhawan, senior counsel. And thereafter, Sir Lordship, on his verification, it was found because I am appearing. The last occasion, so I have received the copy because I have not contacted this respondent lordship. So I have not gone through that lordship. It is at some other date. So in the meantime.
It's on 21st June 2023. That is because notice was no, that I have seen.
Yes, that was to serve to Mr. D.P. Dhawan, the learned senior counsel lordship. So I was not served. Though I have filed total 2006 lordship.
So Mr. D.P. Dhawan is appearing. You are also appearing. One of the counsellors.
I am also Durga Prasad Dhawan. So it is served to D.P. Dhawan. Yes, lordship. And senior
counsel. This is a case of persons of two similar names. So supply one copy in the course of the day. We are taking the matter on 23rd of August. So come prepared.
Lordship.
I don't mention in lordship, the name of senior counsel D.P. Dhawan may be taken.
Should not be there.
Lordship.
His name should be deleted.
Deleted, dear lord.
Okay. You also write. No, Mr.
Full name.
All right, Mr.
So I am Durga Prasad Dhawan.
Mr. Durga Prasad Dhawan, counsel, stated that he is appearing for the opposite parties.
For one course.
Opposite party number 1.
Shots.
Not Mr. Devi Prasad Dhawan, senior counsel. Accidentally, the copy of this special leave petition has been served on Mr. D.P. Dhawan, senior counsel. We will request Mr. J. Kotokiel, an additional government advocate who is appearing for the petitioner, to serve a copy of the said petition to Mr. Durga Prasad Dhawan, counsel who is appearing for the opposite party number 1 in the course of the day. Let the matter be listed on 23rd of August 2023. Huh? Do you have the copy with you or no?
Not now, or not, sir.
Come with the copy. Stuff. Your good name is?
Abhishek Pradhan.
Mr. Abhishek Pradhan, counsel having appeared on instruction of Mr. D.P. Dhawan, senior counsel, has requested this court to delete the name of Mr. D.P. Dhawan, senior counsel, from the records. So, that was an accidental stuff. There is no reflection of Mr. Durga Prasad D.P. Dhawan and senior counsel in the record.
Yes, I am serving the copy just now.
So the D.P. Dhawan list is directed to reflect the name of the counsel of the opposite party number 1. Yes, Mr. Durga Prasad Dhawan, with the full name, to avoid any sort of confusion.
Yes, I am serving the public copy.
Just you supply it, please. In the court, and if you do not file any objection on 23rd, we will just allow this leave and we'll admit the appeal. So you file the objection by 23rd.
Yes, Lord. Item number 21.
21, my lord. Honorable Mr. the conducting counsel, I am being instructed by the CME to adjourn this case and take up it on any other day, my lord.
There are two miscellaneous applications pending.
No, your lordship,
You have no instruction. The request of Mr. Sumit.
only my lord, duty in the endless, my lord.
Ms. Sumitra Mahanti and counsel appearing on instruction of Mr. A.K. Mistral and counsel for the appellate. Let the matter be listed on this. 12th of September, can it be there? 12th
Yes, sir.
Huh? 12th of September.
Item number 24. 22 is already taken over.
My lord, I am for the respondents. My lord, senior advocate S.K. Patnaik was appearing in all these 29 cases. I appeared few days back. I have not got the entire file with me. I may be allowed
This
one or
cannot be the ground. Try to understand. This cannot be the ground. If you are appearing, you know the court will ask you all the questions that would have been put to Mr. Patnaik. So why don't you come prepared in the court?
My lord, file is to be
This is the internal
from Ram Kalaman.
It is the internal arrangement.
My lord, next week I will. Next week.
I am there in some of the appeals and my friend also is there.
I am appealing for
Mr. Sahu is
last
also.
result appeals.
Yes.
All the matters are from 23 to
24.
24.
All items covered to arising out of the same judgment, it's a common judgment.
Common judgment. So what to do?
My lord, next week it would.
We are fixing the matter on the 1st of September.
1st of September, yes.
And we are mentioning that no accommodation will be made to either of the parties. We will hear the matter.
Yes.
We also want it to.
Yes. Interim order is there to continue.
So all matters now these are coming down.
Yes.
Interim to continue in all the matters. Your good name, sir?
Umakanto Misra.
At the request of Mr. U.K. Mr. Land Council, you are appearing for the respondent.
Yes. Provident Fund Commissioner.
Regional Provident Fund Commission.
Appearing for the Regional Provident Fund Commissioner respondent. You are the sole respondents.
Yes.
Both of the respondents. For the respondents, let the matter be listed on 1st of September. That is Friday, no, there is a issue.
Your Lordship, there are two respondents. One is RPF, another is
part of the Provident Fund Commissioner.
Yes. Organization.
That is why I have reflected respondents.
Yes, respondents.
First cannot be Friday.
First is Friday. Yes. Can it be fourth?
So many matters are there. Fifth cannot be. Any day other than 4th. 11th of September.
Your Lordship, till 12th I will not be there, Your Lordship. I am out of state.
Till
13th, Your Lordship.
13th of August.
13th of
September.
13th September, Your Lordship.
It is made absolutely clear that no further accommodation will be made to either of the parties, considering the age of the case. And this matter, all the appeal element and logos appeals will be heard on that day. We will just reflecting your names, the respective appeals.
Yes.
You just go on order, see the council's name and pass it into the same one simple order.
Right.
In the same page, and then photocopy it, place in the other files. All right.
Interim order is there to continue.
Interim order is passed earlier, shall continue. All right. Okay.
I have a small request, Your Lordship. Here it is because earlier when we used to start the practice, the interim order once it is given, Your Lordship, it was to continue, not from day to day. That is causing difficulty.
Absolutely.
Is it?
In this court, there is one order giving the authority to all the subordinate courts against those interim order.
Yes.
When High Court passed the interim order.
Yes.
Irrespective of whether the High Court vacates that order or not, after 6 months, those will be treated as automatically vacated, and the court are now proceeding.
No. That ACM resurfacing matter has taken clarified, but it is not intending for all courts, Your Lordship.
No, that is
not absolute for all the cases.
Not all the cases,
Yes.
but this order is there in this court.
Yes. It was passed in the first order. That's right. Directive was issued to the lower courts. That's right. No, what I was saying that instead of next date, if the university is convinced that there is an issue order to be given, so let it be protected for the other side.
Next effective date.
Effective date. Yes.
But nobody is getting anywhere prejudice because
sometimes it happens that
until further orders.
Yeah, Lords.
So if we vacate, that will mean that.
Yes, yeah, Lords. That's great. Item number 25. Lord, appearing for the private respondent here. Yes. Lordship would see the last order dated 13th of February 2023.
He is appearing for the appellant in this matter.
Appellant is
Mr. Behra, are you appearing?
I'm appearing for the state, Your Lordship.
Okay. Miss N. Sarkar.
Yes, Mrs. Sarkar is appearing for the appellant.
She is not here.
She is not there.
What is your submission? Last order means?
Last order means 13th of February 2023.
Right.
Order number 8. It was heard at length. Then on his prayer, whether she can be accommodated in some other center, and its state council had taken time to obtain instruction without interfering in our engagement. That instruction has still not come. Your Lordship may grant me one more opportunity.
All right. 13th, no, there is a date. 13th. We are fixing it again on 13th of September. At the request of Mr. HON'BLE and Council, appearing for the opposite parties number 1 and 2. Respondents number 1 and 2. It is an appeal, I think. Appeal. Respondent number 1 and 2. 1, 2, 3, 4, 5. 1 to 5. The matter will be listed on 13th September 2023. Meanwhile, Mr. Behra and Council shall obtain the instruction in terms of the order dated 13 to 2023. Mr. P.K. Roth, you are appearing for 1.
Good, I am appearing for the respondent number 6.
Senior Counsel is stated by what is your name?
Mr. Adhiraj Behra.
Mr. Adhiraj Behra appears for the opposite party, respondent number 6.
Respondent number 6, man.
This private respondent number 6. Okay.
The difficulty will be that there is an eligibility requirement that the Anganwadi worker must be of that same locality.
Service area resident. That is the whole issue. But this order is a little, will be difficult.
The facts are peculiar.
Because the court would express the intention that the court will not going to disturb the appointment of the 6. So whether the appellant can be accommodated in some nearby Anganwadi worker or not. Because there is a thing that in the guidelines of the engagement of Anganwadi worker, that you are restricting the guidelines is of the same village. It is not merely the service area.
The same village.
Village/service area. That way that has been provided. So that way you just bring the instruction. Because after all the years the respondent number 6 is served, from that last order it shows this court was not inclined to disturb her engagement. So bring that.
Item 26.
I, on behalf of Mr. A.R. Das, appearing in this case, my lord. In this matter, we have not received any instruction, my lord. It will be granted, my lord.
Item number
26.
You are appearing for Mr. A.R. Das.
My lord.
May I know your good names?
Sanjukta Mahanti, my lord. Sanjukta Mahanti.
MS Sanjukta Mohanty, Learned Counsel, appearing on instruction of Mr. A.R. Das, Learned Counsel, the appellant has submitted that counsel doesn't have any instruction. Stop. In view of the above statement made by Ms. Mohanty, we dismiss this appeal for non-prosecution. MS Mohanty, you are for one on.
I am for 1, 7 and 8.
Counsel appears for the respondents number 1, 7 and 8.
Legal also present.
All right. 1, 7 and 8 and Mr. D.K. Mohanty. And counsel appears for you are appearing for anyone in this matter?
8.
9 and 8. Judicial magistrates?
Yes.
For respondents number 9 and 10. Next.
Item 47. My lords, here in this appeal, I am instructed to appear on behalf of the appellants. But before I take my lords to the merits involved here, there are certain IAs at flag J, K and L, thereafter flag M and O with regard to substitution and inclusion of parties. The parties have died in the meantime. Some of these parties have died. So let the record, Lord, I request and pray, my lords, let the record be set right for the purpose of the substitution applications. If the other side has got any objection, they may file it, otherwise.
Though I having served with the copy of the IAS, I was trying to contact but unable to contact my clients because the original by whom I was engaged, now they are no more. So my restitution submission, the other respondents I was contacting, they don't have any good relation. So my restitution submission notice may be issued. So
no notice to is it to be home to the legal year.
Legal years. So for other respondents for whom I am appearing, I was contacting. If you have contact number,
all right, that may happen also. The person who has passed away.
Allow the substitution and issue notice to the legal answer. Everything will be set right.
Yes, one of the substitution petition is 558.
Right. 558, that is in connection with respondent number 5.
And any other?
There are also other.
Yes.
13.
561, 562 and 563.
This application is barred by limitation?
Not, yes, the limitation is, issues are there. So notice should go on these matters. Let them file their objection if any.
All right. It's IA number 559 of 2023. Heard Mr. P.K. Ratan, Senior Counsel, is stated by Mr.
Adhiraj Behra.
Mr. A. Behra, Learned Counsel. This is an application for continuing the delay in preparing the substitution, continuing the delay of 453 days in filing the substitution petition after date of the respondent number 5. The issue notice as to why the said delay shall not be conducted or any other order shall not be passed. Notice is made returnable on 27th of September 2023.
27th of September.
The applicant shall take steps for service of notice. The problem is that now you cannot take also steps because you do not have shown who was these opposite parties. How can you take steps? Because substitution you have not allowed.
I'll have to take.
There is no change in the cost title of the appeal.
Right now. I'll take steps on the proposed legal aids. I'll have to take notice on my lord's order on the proposed legal aids.
Steps will be taken in the IA, I think.
IA.
In IA.
I'll not take notice in the IA. Yes, the proposed legal aids.
Even they just come to your substitution petition.
Right.
Who will be substituted in place of this?
Kindly see at the first page. They themselves have applied the 5A to 5C. Suryakanti Patel, Sanjay Patel, Ranjan Patel.
Where?
But at the first page of my substitution petition is there.
This is a 559.
It's 558. IA 558.
Okay. But these names should have been also there here.
And schedule is also there. There is a schedule attached to this IA.
On the, who is appearing to the appellant in this matter?
Appellant is myself, Lord, I'm appearing for the appellant.
All right. You are appearing here also for the legal ears of the respondents.
No, I'll have to take notice on them. They will be appearing.
No, that is why I'm telling you that I come to this 558.
558. 559 is the limitation application. Application for condemnation of delay. 558 is the application for substitution.
No, because they come to the cause title in the matter of what is their status then?
Well, legal errors of deceased respond number 5. That the proposed.
All right. The applicant will take steps and the legal errors of the deceased. Pankaj Lasan Patel, PL Patel.
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 Suryakanti Patel, Sanjay Patel, Ranjan Patel. These are the three.
His name is Pankaj Lasan. He is the respondent of 5.
Right, Lord. He the
Pankaj Lasan.
This is respondent.
Pankaj Lasan Patel. Pankaj Lasan Patel, whose descriptions appears in IA number 558 of 2023. The petition for substitution filed by the appellant. So steps will be taken within 3 days, 3 working days from today. The registrar post to the returnable date given 26 September. 27 September. All right. Within 3 days you take steps.
I think so. So far as the other IAs are concerned, the same order, only the party name will be different. The district can take care of IA 561. This is for respond number 38. This is respond number 38.
This is a substitution petition.
Right, Madam. This is substitution, setting aside abatement, condemnation of delay. That is at flag.
Is it 562?
5 flag M, N, and O. 561, 562, and 563.
Is a condemnation of delay of 1,582 days in filing the substitution petition. In respect to substitution petition for bringing the legal representative of the respondent number 38 in WA 351 of 2018. The same way, but the legal representative whose name appears in IA number 561 of 2021, which is the petition for substitution of the others, same date. Then
I take the liberty to travel little further to my notes. IA 565. It's an application to include.
What about 563?
But that is all these 3 not 5.
No, these are abatement already.
Right. Those 3 matters I'll take notice. Then one more IU number 565 of 2023.
564. 564.
All does it.
This is an impletion.
That's an impletion. There also I have to take notice. The legal S will appear or not. 564.
This is a 565 and 563.
This is 563 is the setting aside abatement. That will go along with that 561. Then one more application 564.
All right, they just all the applications,
huh?
Or Mr. 76. This is an application for submitted by the cost title. Issue notice, returnable on submitted.
Right. I'll take out notice in 564 and 565
by the same date. Same all the year in notice.
So one just more request. IA 566. I want deletion of a person as a party because he has no legal heirs. Despite 26, I have requested to delete their house name.
Already, I number 566 of 2023. This is an application for deletion of the respondent number
26, Damodar Patel.
26, namely Damodar Patel, who passed away in the pendency of the appeal, and is not survived by or without leaving any legal representatives to carry forward the cause. Stop. Yes, it has been stated that the respondent number 26 has passed away without leaving a legal representative. The name of the respondent number 6 with description is deleted. However, if any legal heirs is there but not known to the appellant, that legal heir will not lose his status to claim for impediment in this appeal. In terms of a rule, this application stands allowed and disposed of. Grateful. Next
item 28.
That's a kindly see order dated 16 to 23. My learned friend was required to file an appeal.
My lord, I'm extremely sorry, my lord. Your lordship may grant one with more time. I'm appealing for opinion number 1 and 2. That respondent number 1 and 2.
And consolidated cost title we have filed on it.
All right. You are appealing for?
I'm appealing for respondent 1 and 2.
At the request of Mr. Budhendra Das, counsel, appearing for the respondents number 1 and 2. Let the matter be listed on 31st of December 31st of August 2023. By the order dated 16 to 2023, those respondents were asked to file an affidavit within 4 weeks, enclosing the relevant documents to show the basis of the calculation of the aforementioned deal amount. This affidavit could not be filed according to Mr. Das and counsel for the respondents number 1 and 2. And he has asked for a short accommodation, placed and allowed. Let the matter be listed on 31st of August 2023. Yes.
Item 29.
Continue. Interim orders passed shall continue until further orders. Mr.
Your lordship, 21st September.
31st August.
Must. I may be pardon your lordship.
The name of Mr. P.K. Mohanty. Yes.
I may pardon your lordship in item number 27. Lordship, there is an interim order. Item number 27, lordship. Interim order of status quo dated 18/1/2019.
Yes, shall continue until further orders.
Okay. Item number 27, lordship.
Item 29.
Your Lordship, I am for the appellant in this matter. I have filed IA for substitution of private respondents number 5, 8 and 9 who are dead in the meantime. The IA is 2609 for substitution of respondent number 5.
Do any objection?
Same order. In that earlier appeal, Mr. Ratho was appearing. There are many respondents who died and they have filed the substitution.
You want the notice should go. Because state is the only respondent.
We are respondents, but some private respondents
also there
are there.
They are the main
They are the contestant. They are the main contestant. We are formally added as part. Where is your meter?
Use Ms. J. Sahu.
Yes, Your Lordship.
Heard Mr. J. Sahu, this first. These are petitions, there is no delay according to you.
This petition IA 2609, that is in time, but IA 2610, that was I have filed limitation petition in those IAs 2610 and 26.
What is that application for limitation?
That is 2611 2611 of 2023 limitation application. That is for respondent number 8.
11 of 2028. Heard Ms. Such and such. Third counsel appearing for the applicant. This is an application under Section 5 of the Limitation Act for condoning the delay of how much delay?
She was not the exact date is not there. She died in 2019 and the petition has been filed in 2023.
In filing the substitution petition, what is the related substitution petition? 2000.
Yes, sir.
IA number 2610.
2610 is 2611 limitation petition.
No, it is yes. In filing the substitution petition being IA number 2610 of 2023, and for death of the respondent number 8, namely Lakshmi Narayan Singh Rai. They issue notice as to why the aforementioned delay shall not be completed. That is made returnable on 27 September 2023. Steps for service. On the there is relating to this application is relating to IA number
2610 that is limitation petition is 2611 and in 2612 the substitution petition for respondent number 9, that is 2613 is limitation petition.
This is 2610. The substitution petition is a what is the detail of the legal years in your petition? 2611.
Yes, Your Lordship, 2610.
2610 is the limitation petition.
No, Your Lordship. 2610 is the substitution petition and proposed legal years is Pranay Kishore Singh Rai at page 2.
And its condonation petition is what?
Condemnation petition is 2611.
2611. Will this order is passed in 2611? To serve the notice on the legal years of the responding of A, whose details have been given in the para 8 details.
Para 2.
Below the para 2. Stop. The steps shall be taken within 3 working days by registered post retailer. So, then
2612 is substitution petition for respondent number 9.
2613.
12.
No, the 13 is the limitation.
Yes, sir. Yes, sir. Yes, sir.
The respondent number 9, right? And the same way the description in IF 2612 of 2003 under paragraph 2 of the said petition being IAS steps in the same date and same everything. Okay.
Lordship, respondent number 6. She is also dead. Her name may be deleted. Her legal hairs are already on record.
Have you filed any application?
No, Your Lordship, I file a memo to that effect.
Memo or application, whatever you file, because we do not know that there is no legal year. Some record should be there.
They're on record. Resolution number 7 and 8 are.
That statement you have to bring on record.
Yes, Your Lordship. I'll file a memo.
All right, on the next day you file a memo.
By tomorrow, I'll file.
No, this is that on that day, my case has been fixed on 27th of September.
Yes, Your Lordship. Obliged.
Next. Item 30 list for how does it go? 31.
Item 31. So this is the case where I have already finished my argument by reaching.
Lordships, I have given it time and notes and dates, Lordships, as directed by my lord, that it dates and events filed by me, Lordships, yesterday. It must be the.
Before my learned friend starts, my lord, may I pray your Lordship may pick this matter any day next week. Here, my lord, and the advocate general will argue this matter.
Oh.
When also fix it on 22nd at 2 o'clock.
Any day, Your Lordship may pick.
22nd, 2 o'clock, other matters. Mr. Naik, do you have any problem?
Lordship, 22nd, I don't have any problem. Lordship, let it be there in the serial so that if it reaches early, I could get it.
That creates an uncertainty because if you say 2, it will be called out at 2.
Definitely 2 called out at 2.
Come at 2.
Lordship.
The request made by Mr. Kuntil and
good practice.
Government government advocate appearing for the state of the on the opposite parties. Listed on 22nd August 2023 at 2 p.m. Stop. No further recommendation will be made. Matter will be heard on merit. So, in the analogous matter, we have already heard the similar issue. Today, Mr. Chandrakant Naik, Learned Counsel, appearing for the petitioner, has filed one memorandum containing some documents which he proposes to rely at the time of hearing.
No, impressive. Actually, WPC number 34769 of 2020. I have argued that is the lead case and he has hard in part already.
All right.
That is the lead case 34769. Now, Lampert can argue also.
I'll cover that. I'll cover.
Dinamanda Das, but this
Copy of memorandum.
34769 of 2020.
ଯୋଉଟା ଦଉଛନ୍ତି ଆଜି ସେଟା ମଧ୍ୟ
In WPC 34769/2022. This matter has been heard substantively. So, and this matter is the lead case among the analogous matters. So, let the matter also be listed on same date. Mr. Rautre, and City Council. Who is estimating?
This is Sangram Jana.
Mr. Sangram Jana. Council for the petition. You have to mention this, that the matter also be listed.
Well,
all the matters, all the matters were identically situated with all these on the list. Let it be there on 22nd.
No, this all the matters are recorded in the orders.
Judgments, let's see, we are taking back. On that day, I'll produce.
To understand same date. Include individual orders, list all the matters together and then put the date and fill the photocopy in the orders.
Let's see, what I am proposing is that serial number 31. My leading case is sub item 2. That is 2019 WPC. So if it
you point out, we have no difficulty to take up this matter.
Item number 32.
Your lordships have already issued notice. However, there is a condemnation of delay application that has been filed, your lordship, but the delay is entirely during the COVID-19 period.
All right. This 650 days delay.
But entirely during the COVID-19 period. The impugned order is dated 12th February 2020.
And against the impugned judgment, we have went to the apex court. And there they have granted liberty to file writ appeal. That is
at page 51, the order of the apex court.
The issue involved the present appeal matter is squarely covered by the division bench judgment passed in WPC number 20651/2016, which was disposed of on in batch of cases, similar cases on 27/6/2017. That is division bench judgment, and as well as there are 3 other single judgment.
Are you ready today?
Yeah, not sure. I'm ready.
All right. Come back to wait for some time because 3 matters are fixed at 2. After that, this matter will be taken up.
Then your lordship may take it up sometime next week. In the meantime, I'll take a copy of that.
Board is so congested, it's very difficult to. Today we may try. Let us see. If we cannot do the, definitely we'll provide a date.
Lordships intervene. Item 55 and 56.
Just don't mention the matter now.
It's along with that 31 item.
Is it so?
It is so, Lordship.
55 and
56.
55, 54. Take that there. Yes.
Yes.
Other 3 matters there. I pray tomorrow if possible.
Which one?
That item 32.
Why tomorrow?
Because the other 3 matters may continue for a long time.
No, we do not know. That is why you are asking you to come. The collapses for any reason will immediately take up this matter.
Item 33.
May pardon, my lord. I am in virtual mode, by item 33. Lordship, last date, my lord, directed for filing of counter by the opposite party 8/10/11. And yesterday, in fact, evening we received a counter from mining department, opposite party number 11. So I require to file a rejoinder.
I think, Manoj, the writ petition has become infructuous because the land, that portion will not be acquired and it has been dropped. It will be done in somewhere else, Manoj. There is a recent development.
That this proposal to acquire the land has been abandoned.
Let them file a document. Let them file a document. To that effect.
We have obtained the status, Manoj, for IDCO.
No. It's a oral statement. It cannot be accepted.
He is producing some records.
I'll file an affidavit if your lordship may direct, but this is the status, Manoj. I'm just.
No, let them file a document.
Proposal for land acquisition has been shifted, my lord, somewhere else.
No, we need to see the copy and verify because the land record is 151 acres, my lord. I need to verify that.
Can you supply the copy to Mr.
I will supply my lords with, I will file affidavit, my lords.
File
File affidavit.
23rd by 23rd file is?
Yes, ma'am.
All right. He will file an affidavit after supplying copy 23rd. I am listing the matter again.
My lord, obliged.
In the meanwhile, also take the instruction if you require to take further instruction.
At the preliminary stage, only Form A that was issued.
No, now it is clear from the
Yes, that's what. I also agree with him because that is for me.
If Mr. Mohapatra this wants to take instruction, let him take instruction 23rd of August here.
Unless until I see the copy whether the land schedule may not 151 acres. 100.
Not on record.
My lords, for OP,
He is 8. I am for OP 10.
IDCO, my lords.
My lord, the whole issue is IDCO in fact acquiring the land through the revenue department for the purpose of a private company.
P. Mohanty means Mohanty. Your name, okay. Mr. P. Pranay Mohanty, that council appearing for the, you are for the IDCO.
IDCO, my lords. OP 8.
Opposite party 8.
Opposite party number 8 has submitted that the High Level Clearance Committee, HLCA, in its 19th meeting held on 5/3/2019, it has abandoned.
My lords, may record the last two paras of the statement.
As the result,
record it has been.
as follows. Keeping in view of this uncertainty and the technical limitation, this part,
my lords,
of the above two sites, it was decided to search for alternative land in Keonjhar district. So it was advised that the IDCO district administration and Messrs. Rumta Mines Limited will further intensify the identification of the suitable land patch of at least 1,500 acres. Subsequently, IPICOL, where the letter number 856/ dated 18/4/2022 has recommended for allotment of 1,600 acres of land of the 3 MTPA Greenfield Integrated Steel Plant projects in favor of Messrs. Rumta Mines Limited, IB Villages, Bhutania, Debang, Bira Krishnapur, Bistapal, Noagaon, Ratnapur, and Katakhamon under Keonjhar Sadar Tahsil in Keonjhar district. The alteration and acquisition process for the same way is under process. Having referred to those passages, Mr. Mohanty has submitted that present reputation is therefore has become infructuous. Be that as it may, Mr. Mohanty shall file a short affidavit with all the necessary information regarding the abandonment of the project. Stop.
The drop of proposal.
Abandonment of the project on the yes, regarding dropping of the proposal.
Petitioner's area.
On the area that the petitioner has identified as a petition. So, Mr. S. Mohanty, Mr. Acharya is there?
Yes.
Registered by Mr. I. Acharya, council appears for the opposite party number 10. Where is Mr. Muduli? T.K. Muduli, Long Division Government Developer, appears for the opposite party number 11. Stop. For the petitioner, Mr. Manush Mohapatra, senior advocate, has appeared. Stop. We would request Mr. Mohanty, Pranay Mohanty, to supply the copy of the affidavit in advance to the council for the parties. Keep on record. Stress during his typing it will be is
item 35.
Interim order to continue till.
Till the interim order as first is shall continue. 35.
35, 34 of the second. Item 35.
My lord, in this case, I'm submitting the documents, the judgments I am relying.
Yes.
Yes. I given all the judgments of Honorable Apex Court and also this Honorable Court regarding that seal cover and promotion during pendency of vigilance and department. Yes. And also I have given all the circulars issued by the government in regard to that. The input order, your lordship can find it. I'll first go, your lordship may go through that judgment. Thereafter I'll place all the judgments.
Start up to lunch.
Madam.
Yes. And Mr. Dolo, there in between there will be 2-3 matters of fixed step 2. After that, this matter will take up.
Lordship.
Because almost you have heard the matter. It come.
Yes, ma'am. 3 matters, your lordship. Your lordship always.
If you are not reaching lordship, only I pay, I will some interim protection, that's only I pay lordship. If you will not reach lordship, otherwise.
All right, let us see what is the situation there. This is 35, no? Stop the matches. Because the earlier fixed matters, that will continue later. Yes.
Item 46. 46 balance. May it only the union has to reply as to why they have not removed by this certificate of the court. And refusal order is at Annexure 1 in one line order. Annexure 1 at page 23. No reasons has been given, though section subsection 3 to section 16 says the reason has to be supplied. And I have given 2 judgments that the reason is the that is my lord's I have given my lord's 1990 volume 4 SCC page 594, and your lordship have also recorded it on earlier occasion, my lords.
That one decision, this
yes, my lords.
Matter relating to S.N. Mukherjee.
Yes, my lords.
And other Justice Chauhan's judgment, Secretary of and Curator Victoria Memorial House, this too.
Yes.
All right.
Yes. And now they say that
they have conducted a field inquiry which your lordship have already produced in the month of April. After that, your lordship passed an order on 17th of April 2023. Thereafter, my lords, they filed an additional affidavit, solved it in the month of July, my lords.
Yes.
And your lordship will see in the additional affidavit, para 6, alleging therein, without any clear assertion as to what I have violated. They say that the contribution.
You are reading from the additional affidavit.
Yes, and also in the counter affidavit also will see.
No, who filed the additional affidavit?
We have filed the additional affidavit. I'll place it. Let my lord and friend will
When have you filed it?
My lord,
When have you filed the additional?
it was filed on 15/5/2023.
Sought to me in the month of July, my lords. And your lordship said, why you are not informed?
You give a copy to us. Do you have
Yes,
a
yes.
copy?
We can give you a copy.
This matter is not uploaded.
It was. Usually it was in
Additional No, there is nothing out there. It's not in the.
I will finish there regarding additional affidavit.
All right. We got it. All right.
Copy, man.
No, so we got it.
Yes.
You are referring to which paragraph?
Melons, para 6 of the additional affidavit. Thus you will see totally vague, no clear assertion has been made, and affidavit has to specify. Thus the findings of the field inquiry which your lordship have earlier produced further reveal that the petitioner has diverted the foreign contribution for undesirable purposes and involved in the activities other than those permitted in the Foreign Contribution Regulation Act, Registration Certificate, and also contrary to the aims and objectives mentioned by the association in its memorandum of association. For the sake of convenience, then the court is not necessary to read all these things. Then para 7. It is submitted that the petitioner association is registered under Foreign Contribution Regulation Act 2010 for social purposes, and the petitioner's association applied for renewal registration for social and educational purposes. However, from the finding of the field inquiry report duly produced before the court, High Court, Honorable Court on 17/4/2022, it is amply clear. That was actually 23. It was 23 hours. It is amply clear that the petitioner has diverted the foreign contribution for religious agenda and involved in the activities contrary to the aforementioned aims and objectives, prejudicial to the national interest. My lords, here, my lords, the Home for the Mentally Handicapped have got 72 children.
In the writ petition, have you asserted it?
Yes, my lords, I have given it. 72 may not have been there, but it is.
It's my better to show you.
Para 3.2, my lords, page 3. The petitioner society situated at Dipupara, Post Office, Jharsuguda, Orissa, has been created to bring rays of hope into the lives of mentally challenged persons and their families through the special school to give training for the holistic development of mentally challenged by early intervention, ADL activities, behavior modification, psychological, physical and vocational training to make them dignified human persons. Well, as my latest information, as I have been informed by the home, that one of that boy, he has joined as a helper in the municipality. He was cured of the disease. And there are now, my lord, cerebral palsy, mental retardation, and another autistic childs are there. Some are in the hostel, some are reading in the school. I have also attached, my lords, the photos that you also will see, the photos of the name. It is there, my lords. That is after page 56 of the brief, you also will find Asa Kiran Center for Mentally Handicapped, Dipupara, Jharsuguda, Odisha 768201. Name of the child is there, Rina Balla, age 17, date of birth is given, gender female, type of disability, MR, mental retardation, percentage 79%, address is also given, name of the parents is given along with the photograph. Now you may kindly see. Likewise, 2, Philomena Minch, age 15, date of birth 27/11/2000, gender female, type of disability, that same mental retardation, 75%. At Kesarmal, address is given. Then his father's name, Carlos Minch, farmer.
All right, that's all, Mr.
Yes. Now they say that religious activities.
No, that the first affidavit also they have stated. So.
Yes, ma'am.
Yes, Mr. Pari.
Yes, my lord. My lord, because everything has been discussed, I am complete.
First of all, the 2 questions from the bench is,
my lord,
whether have you checked their audit report? Because that is the only important document to get support of your allegation of the diversion of fund to the religious activity.
Exactly.
In your affidavit, there is not a single murmur that we have checked the audit report also. You are always saying they are permanent, and there is no sort of any document, nothing complaint from anyone. Where from your officers are getting all this information? They have also annexed the audit report with their affidavit. And there is no reference to that. That is number 2. And obviously, they are running an institution of the physically challenged children. And 72 inmates are presently there. Are you against this institution? Run by the citizens of this country.
Yes, ma'am.
And only your objection is this is an objectionable activities against the national interest. Any police report against them?
My lord, as regard to the question number 2 is concerned, I have to say that we cannot will abide by this citizens charter, and we can't go beyond their things. But simultaneously, we have to see the conduct of this citizen and what way they are acted upon.
Exactly.
Yes. So in paragraph 5 of our counter, specifically stated
in
additional affidavit, specifically stated, even the person has been died, he is in the committee, and in the name of him, they are submitting application. This sort of thought they have committed, that's why. The section 12, subclause 4 of this statute, my lord.
Yes, read section.
Yes. I am just reading, my lord. Section 12.
Yes.
I am just running paragraph, paging I am not there, but in additional affidavit, let's see,
paragraph 5, I am just reading. It is submitted that
You have annexed the act
yes,
with your affidavit.
yes. We have also quoted, my lord, in this.
Yes.
Yes. This in paragraph 5, let's see for a moment. That it is submitted that as per the mandate of section 16 subclause 1, a field inquiry was conducted by the Central Security Agency and findings of the field inquiry ever that one of the office bearers of the association is fictitious as he died in April 2020. At this juncture, it is pertinent to mention here that the petitioner applied for renewal on 24/2021 and they mentioned that deceased office bearer in the statutory FC 33C form, despite knowing the fact that the office bearer has already been died in April 2020. In view of the aforesaid facts, the petitioner has given false information and violated section 12 subclause 4AI of the SARF 2010. For the sake of convenience, section 12(4)(a)(1) of FCR 2010 is reproduced below. 12(4), my lord, I am straightway coming to 12(4). The following shall be conditions for the purpose of section 3, namely a person making an application for registration or grant of prior permission under section 1. They are not giving their prayer that their issuance of certificates. Straightway they are challenging the annexure 1. Speaking order has not been passed. I am so admitting that for some other reason the officers were simply written such and such. No speaking order has been written in this regard. But let's say come to the simultaneously I is not fictitious or benami. Here the case on even though a person has been died on 2020, he has submitted application 2021 saying that he is alive. His name was submitted to the authority. It was on inspection it is found. Number one.
Whether he is dead, any report is there?
Inquiry report is there. He has admitted he has died.
Who admits that? Mr. Rai has admitted you applied.
No, my lord.
By dead person also included in your society?
No, my lords. What he is alleging now, I have in my that audit report, Lords will kindly see, because I have which I have submitted, my lords, that is 2021 at annexure 12 and 13, is 96 to 105, my lords. The audit report was submitted.
No, not that. He is raising a question.
My lords.
Someone of the society's executive member, he has already passed away.
My lords.
When you filed the application in 2021, he died in 2020. He is also included as a member of the executive committee, and he filed, and according to him, it is a fraudulent act to deceive the central government to get the renewal of the.
I'll check out that, my lords. I'll come back to your lordship, getting an affidavit, my lord, who has died and when he has died, or
because this is allegation has been made in their affidavit also.
My lords. Then I'll get that information, my lords. So far, I have not. I'll
all right. You adjourn the matter.
Yes.
31st August. If you like to file anything,
yes, you can file it.
I'll file that.
Matter of record will file affidavit. So
all right. The request of Mr. S. Royal and Senior Counsel is stated by Mr. K.K. Sahu, appearing for the petition. We are registered on 31st of August 2023. In the meanwhile, the petitioner is given liberty to file the rejoinder or the reply affidavit in respect to the additional affidavit that has been filed by the Union of India by the opposite parties. In that rejoinder, for purpose of continuity, the petitioner can also refer to the amendments made in the counter affidavit that was filed on 9/2/2023. Mr. P.K. Pari, Deputy Secretary General of India, along with Mr. B.S. Rai Guru and its CGC, was appeared for the opposite parties.
I'll file an affidavit, man.
Sorry, yes.
Obligement. The number 30. Obligement.
Is
The Lordship, I've seen that Mukul says a case. Then second case, your Lordship see. That is from Odisha. In Mukul Saike's case, I've read the paragraph 30. Yes. Now your Lordship see paragraph 44. First case.
you are appearing in the
9 and 10.
In particular case,
9 and 10.
all the cases 9 and 10.
9, only 9 and 10 and this particular case. Second.
Last case.
19875 of 2000.
19875.
All right. This is where you are appearing. You are appearing in this case.
Yes.
All right. For 9 and 10, respondent number is. Yes.
Malak. Malak, there is a well. This original fact, select list prepared. They cannot go beyond the appointment, cannot go beyond the notified vacancy. Malak, your Lordship gives annexure 1 notified vacancy. Annexure 1 of the writ application notified vacancy. And page 2. Yesterday also I have in order to annexure 1, page 20, in order to fill up the existing and anticipated vacancy in the rank of ASU by the end of 2007, a pre-promotional test is to held shortly. This question read with counter filed by state government in 516. That is annexure.
Mr. Patnaik, that just most of the facts are admitted. There is most of the facts are part of the fact. Only legal question we are considering that in view of the new rule, which was enacted in 2021.
I'm not appearing in that case. I do not. I only appeared in this case.
Okay. You argue in your own way?
Well,
yes.
Annexure A by 9. At page, my counter page. The state government said that in order to fill up the 20, that it says that vacancy, in order to fill up the 20 vacancy.
You are referring to A by 3?
A by 9. There's another counter type. Next 8 and 9. 9 and 10.
Yes.
Also got it? Well, before, in order to fill up
Mr. Apul Kumar Sahu.
Yes, ma'am.
Yes.
That before relying on the merit of the case, the background of the case, according to the respondent, is narrated. That in order to fill up the 20 vacancy in the rank of assistant station officer, a written test was conducted in the year 2007.
in accordance with the provision prescribed in 660 of Odisha Police Manual. This policeman, you lordship see the policeman. Police manual doesn't prescribe any period of select list. But however, Annexure 1 speaks of 3 years. Suppose there is if that is accepted by where a version is accepted, if there is no statute doesn't provide any, then it should be 1 year. Why it is continuous for years to be decision as if it is a permanent source. Your lordship, that's why I have given you, your lordship, see the decision in my first decision in Mukul Saidya. Mukul Saidya.
Yes.
It's a past decision I have given. My lord, that is 2009, 1 Supreme Court 386. Page, your lordship, see page paragraph 30. Paragraph 33. Paragraph 33. This is the sort of, he has report shortly the fact is this. At the outset, it should be noticed that the select list prepared by APSC could be used to fill up notified vacancies and not future vacancies. If the requisition of the advertisement was for 27 posts, the state cannot appoint more than the number of posts advertised. Even though APSC had prepared a select list of 64 candidates, the select list got adjusted when all 27 posts are filled up. Thereafter, the candidate below 27 candidates have no right to claim appointment to any vacancy in regard to which select list was held. The fact evidently admitted that names of the appellant appeared select list dated 1/7/2000 below the persons who were already appointed on merit against said 27 vacancy, and as such could not have appointed in excess number of posts advertised. That's what happened in our case. Your lordship, see is paragraph. What say? Paragraph 44. Paragraph 44.
Yes.
It is well settled in law, filling of the vacancy over and above the number of vacancy advertised could be violated by Article 14 and 16 of the Constitution of India. The appellant's name in the select list of the direct appointment does not confer any right to the appointed against the vacancy. That is there are other issues are there. Minor 46. In facts and circumstances of the present case, we find that High Court has rightly held that the appellant don't have any enforceable right being appointed to the post of CDPO against the quota mean for the promoting, and particularly against the decision of the state government regularizing the service of the private reprobate. The cabinet decision was taken as a one-time measure having regard to the special circumstances of the case. The satisfactory performance of the respondent by the private respondent and then paragraph 47, the last. In the circumstances, the High Court is right in holding that appellant have no representative. This next decision, my lord. This is from Odisha. 2010 6 SCC 777. State of Odisha versus Rajkishore. Para 17, you have given the brief fact of the case. Para 17, yes, at page 784. Well, earlier to this, in paragraph 15, 16, he has Let me read from the 15, page 15, paragraph 15, 783. A constitutional bench of this court in Shankar Das vs. Union of India, and name of the candidate in select list don't give the right to be appointed. Then paragraph 16, select list cannot be treated as a reserve for the purpose of appointment. The vacancy cannot be filled up, taking the names from the list as and when it is so required. It is settled legal position that no relief can be granted to the candidate if approaches the court after expiry of the select list. My lord, here in this case, if that is their case is accepted, it is not 3 years. So then there is nothing provided in 660 regarding the validity of session. Then it should be followed 1 year. You should. That is the decision I have given, my lord. I will come to that later, my lord. Another decision I will read it, then I will come to that. Next decision is 2014 OLR 400. Basing on this decision, they have decided. Similar decision. Yes. Another decision is my decision is same line, my lord. Thereafter, your lordship come to this is one Rajasthan decision. SBC.
Why are you referring to Rajasthan decision when is
yes, that I am referring. That I am referring. Why? My lord, I have said that if they have said that there is no there is
that's that case.
No, there is no limitation for select list. It should be like a job. If the statute doesn't provide that, then it should be construed as 1 year. But to that I am stating the Rajasthan decision. State of Rajasthan versus Jagdish Chopra. Your lordship on to paragraph 8. Paragraph 8. Lord and Council submitted. Your lordship got it?
Yes, yes.
The Lord and Council submitted that Rule 93 does not fix the period of validity of the panel, and in view of the matter, the respondent who was on waiting list should have been appointed as one of the selected candidates could not join. Recruitment for the teachers of the state in Rajasthan admittedly governed by statutory rules. All recruitment thereof are required to be made in terms thereof. Although 993, the rules does not specifically provide for the period for which merit list remain valid, but the intent of the legislature is absolutely clear. Our vacancy have to determine only once in a year. Vacancy which also arise subsequent years could not be filled up from the select list prepared in the previous year, and not in other manner. Even otherwise, the absence of any rule ordinary period of validity of select list would be 1 year. In the state of Bihar, but that your lordship also stated. That is quoted with the Bihar decision. Paragraph 9. In the aforementioned situation, in our opinion, he did not have any legal right to be appointed. Life of a panel, it is well known, remains valid for a year. Once it lapses, unless appropriate order is issued by the state government, no appointment can be made out of the panel. Further in paragraph 13, he has quoted. Next decision notice therefore.
Mr. Patna, it is the same thing, same principles of law you are reiterating. But so it's well received by us. You say that even there is no provisions in the rule, the principle that will be followed, that is 1 year will be the maximum life of the maximum. Beyond that, it cannot go. And being in the wait column doesn't give someone any right to get appointed. Being in the wait panel doesn't give someone any right to get appointed.
Yes, ma'am.
Already that we got this point.
Right. Well, that next decision is that we have this. He is quoted that
Amarendra Singh. That you have read already?
I have not read.
You have to read. Okay, read.
Your lordships. Anyway, my lord, that's paragraph 9 and 13 he has recorded.
The relevant part of the Amarendra Singh has been quoted.
Yes, ma'am, that quoted.
Yes.
Your lordships.
In Justice Johan's judgment.
My lord. In this instant case, my lord.
Yes.
We have filed this case. It should not be 50% and 30% you qualify mark, and you accordingly you rearrange the list and then prepare. That is our case. 50 then.
Now, what is your case? What is your case?
Your lordship, see, prepare the.
What can be your case? You are opposing their prayer only.
Then, my lord, your lordship,
you cannot ask for any relief by you filing the counter affidavit.
That's right, my lord. But how one thing for us and one thing for them. If that 660 doesn't prescribe any qualifying mark, and they say that 3 years rule also not granted. Annexure 1, in Annexure 1, 3 years is not also stated.
So they one says that it can continue beyond 3 years. Their case is very categorical. You said even it cannot be 3 years.
Yes, ma'am.
The maximum period should be 1 year. All right.
Which document? Yeah. Annexure 1, in one hand, they say that if there is no 3 years even, or beyond 3 years, they can be appointed beyond 3 years. But how? They are not qualified. The rule means that is 66 rule. There is no rule. 660 is followed. 660 followed with the practice in police department. 660 followed passed in police department. Police department says there is no it is not limited to any period. If police department clarifies something, there is not limited. But this thing also, that 50% to 30%, that is practice. That is 50% earlier in police department. That is quashed in 2003 by this honorable court. Thereafter, the government has issued a notification in police department. It should be 30%. That we have annexed as Annexure 4 to the writ application in challenge. But that is not, though it is argued, and this is not found place in the judgment or any discussion about that. Whenever say same thing, you for 3 years you say one thing, but same thing for 50 to 30% qualifying, you say another thing. And then we have not discussed it, though we have given that in Annexure 4 of the Convention judgment. So, that's
only 2 minutes. So far, Mr. Patnaik's argument. So look to page 46, the judgment. Page 46. Mr. Patnaik has been added, clients have been added as opposite party number 8 and 9, Gaurav Chandra Pradhan and Akhil Kumar Sahu. Page 36 of the brief. There are 5 writ applications. So far as these opposite party number 9 and 10 are concerned, Gaurav Chandra Pradhan WPC 776 of 2015, Akhil Kumar Sahu WPC 920 of 2015.
So what is their 9 and 10 writ petition? WBC number?
Akhil Kumar Sai is 9/20 of 2015. And Korak Chandra Pradhan is WPC 776 of 2015.
Yes.
Judgment, they challenge the tribunal's judgments. They are not parties before the tribunal. They are not parties before the tribunal. They straightway came forward and filed this writ application. Just try, please. You also look to page 37. It starts with the paragraph 2. The writ application is under Article 226 and 227 of the Constitution of India, wherein the order passed by the tribunal in order number so is under challenge. Then, finally come to paragraph 4. Their entire case was that should not be 50%, that is 30%. That's what look to the prayer was been quoted also. Paragraph 3. The case of the applicant petitioner with brief is they are working as a leading fireman and intend to be promoted to the post of assistant station officer. Accordingly, they appeared in the written test held on 22/9/2007, but they failed in the result published on 16/10/2007. As such, they are approached to the tribunal with the following prayer. 1. May direct the respondent to prepare a press list. They have come to the tribunal in 2015. The select list was prepared in 2007. We direct the respondents to prepare a press select list of candidates, those who have secured 30% mark in every grade, and only are declaring to have passed in the written test to be nominated for promotion to the assistant station officer and training. Then 2, to direct the respondent not to give a tick to the selection list under Annexure 2, the first selection list is prepared and declare promotion of opposite partner for others viable in the year. That means that the prayer was 30% mark a press release is to prepare, and on that, still that date, it should not be given a copy. But also kindly come to the next page, or page 48. That was the entire case. That should not have been 50%, that is 30%. My lord made an attempt to argue that matter because he is the opposite party. They have not challenged the judgment. They have challenged the judgment before the Supreme Court and so on. Perhaps so. Lord additional government advocate, Mr. M.S. Sau, and so, and intervener so, have vehemently opposed the prayer made on behalf of the petitioner by submitting that there is no insanity in the order, into the order, state house, with a state case. They have submitted that there is no formulated by the state government governing the recruitment of the promotion bill for the post of assistant section officer. The government in such a situation, in the case of the state, in such a situation, has adopted the provision of Rule 660A of the police manual. They have submitted that the provision of Rule 660A of the police manual does not contain any time limit. As such, once the list to be prepared on the basis of the pre-promotional test, it will remain valid till it is exhausted. This is a specific case of the state. And the judgment has already shown to us by the place. So far, Mr. Patna's client is concerned, if you also look to the judgment which was subject matter of challenge, that was the judgment I have annexed as annexure B by 3 at page 30 to the counter. I want to show you also they are not party before the tribunal. The law is, if suppose somebody is not a party before the tribunal, because when the tribunal was in functioning, they could have filed an application for review, or they could have filed an application then and there in view of the judgment passed in that 2006 Supreme Court. And a judgment, division by judgment in here. Anyway, but you also look at that judgment. By one is trying to dispute that they are not parties to the judgment of the tribunal. No, they are not parties to the judgment of the tribunal. The two original applications that annexure B by 3 at page 30. Proposed to my Perija, these are the petitioners. 751, 723, 929. That was also kind of page 30, annexure B by 3. So therefore, they have stated at their entire case before the tribunal of these 3 years, that is also similar. They appeared the pre-promotional test but could not qualify because of they have secured less than 50%. And the tribunal, referring to the PMR rules, have come to a conclusion till it exists. They accepted the state case, entire case, tribunal. And that was challenged by a third party. Now, again, the judgment, so actually, this opposite party number 8 and 9, they have approached the tribunal challenging the judgment. Take that 50%, 70%. Plus, we look to this, the parties name and the number of the writ application. When there are cases in that should be 30%, not 50%, that will be dismissed. Now, my young friend has now appearing for the opposite part number 8 and 9. Can we be allowed to argue so far the correctness of the judgment of the tribunal? Of course, my one friend says that the judgment is in the air because 30% has not been taken into consideration. But point is not there. So far the first writ application is concerned. The first writ application confines to the validity of the lease after expiry of 3 years. In fact, the state government has given promotion to 107% and also given promotion to 80%. And because of the judgment of the tribunal, because of the judgment of this court division there, of course, the previous case of the state, we are undone. So our entire case was in favor of the present petitioners. But we take just that they have implemented that. So I leave that placed further. My one
more. Your lordship, see my written argument. The opinion number 9 and 10, you have filed away. They have stated that we have not filed away, but we have filed away.
No, the judgment.
I have never heard. Yes. That opinion number 9 and 10 filed OE number 2576C of 2011 and OE number 3130 of 2012 respectively before the OAT Cutoff bench with 42 applicants on different petitions. All the OAs were heard and a common judgment is delivered on OA 516 of 2012 and batch on 19/12/14 with a prayer to reduce the qualifying mark 30% from 50% as followed by police department in pursuance to judgment of the honorable court reported in 2003 to OLR. The honorable tribunal filed once you have accepted the condition in Annex 1, you cannot go back to challenge the same after having been unsuccessful in that while passing the judgment of the honorable tribunal observed as per, that is 1 year, paragraph 3, your lordship. The advertisement was published by the Director General Police on 26/15 for place promotion test. The successful candidate in PP 2007 under Annex 2 have challenged the advertisement on 26/15 in OA number 751, 756 to 756 without making the party to the applicants in OA number 516 to 12 and dash. And the learned tribunal held that by order 22/15 was the advertisement dated 26 and held that observation in para 9 of OA 516C12 and batch not binding and list published on Annex 2 will continue till it adjusts. Thereafter, we have come to because when we see that it is a continuous and all the 300 portions of then only we have come to approach this court, challenging both 751 judgment of 751 and 751 and 516. Both the judgment we have challenged only because when we see that all the 300, if it's not adjusted, then we don't have a scope. We may be retired at the relevant time. So we have come. We have not come. All the they thought that we have not filed any way. We have filed away, but we accept the judgment. But when this second judgment has passed by some of the successful candidates and got that list should be continue till it is adjusted, then actually we are agreed. That's why we filed. Now our judgment is challenged here. Our judgment challenged. No. 7 times. We have filed, madam.
Have you filed any appeal? No.
Madam,
you have not filed any appeal. You are
No, we have not filed.
only defending the judgment.
Yes, ma'am. That your lordship is correct.
So that is why I think Buck stopped somewhere. Please now
That's
conclude your submission.
Then that's I have given my submission. These things have these universities have done.
Can I take just 5 minutes of your lordship?
Universities has done. Your lordship can see that also.
Okay. You mean to say that these if the wet panel is still continued for appointing these appellants here, it will be the injustice to you.
Yes, madam.
All right.
We'll return. We'll be returned.
My lord, I'll have 3-4 submissions to make. Facts your lordships are aware of. Now, my lord, the present petitioners were not parties before the tribunal in both the cases. They were not parties before the OA in both the cases.
Correct.
And obviously, when this writ petition was filed before your lordships, challenging the 2 orders of the OA, they were not parties. Because whoever is challenging the order of the OA will only make those people who were before the OA as parties. Now, some of them were parties. And in all fairness, my lords, they should have got implemented themselves as parties. Having not done that, in my submission, my most respectful submission is, my lords, they are fence sitters and therefore they have no locus. Your lordship, I only know one
already indicated on the last occasion.
Yes.
Fence sitter.
Yes.
The problem is that
yes, madam.
Fence sitter is a person who is also not affected by the judgment.
But he is watching and not watching the court.
Fence sitter is the person who just waits for the opportunity when the judgment goes in his favor to come and like to take the benefit. But if the order is as such, some judgment affects their interest and they are not party. Is it a proper judicial process? And Justice Cardozo says that the killing a person by the judicial sword who is not seen in the process.
I'm grateful. Let me straight away answer this question.
Yes.
These petitioners were aware that here is a case where 2 orders of the tribunal have been challenged. And they were going to be aggrieved by the decision of your lordship's court. So in fitness of things, they should have become parties before your lordships.
Yes.
It is nobody's case that they were not aware of the litigation before the tribunal of this honorable court.
It is also nobody's case.
Yes, madam.
That they were aware. That is what you have argued, the arguments are made.
Yes. I will not labor much on that. This is my submission to you. And, my lord, there were interim orders passed by this court, my lord. So they were obviously, my lord, if somebody is sent for promotion or waiting for promotion under a particular select list,
yes,
and he comes, he knows that a litigation is filed, it is reasonable that he will come and appear. This is one submission. I'll rest it at that for your lordship's consideration. The larger question is, my lords, admittedly, today we have a rule. And that rule we have framed pursuant to directions of your lordship's court. Admittedly, as on today, my lords, there are 169 vacancies.
Yes.
Now, these vacancies are to now be filled up. Your lordships have held, my lords, in a series of judgments. And your lordship may note, my lord, 2017 3 SCC 646, State of Tripura versus Nikhil Ranjan Chakravarti, down the line.
Yes.
Your lordship has seen Rajkumar and Krishna Kumar is what my learned friend has said. I will not cite those judgments. Para 9 of that judgment says, once new rules have been made, then all appointments, promotions, etc.
have to be considered under the
new rules. So that is my second submission. But your lordships are wondering that why I am arguing so much. The answer is this. I have been not able to fill up one post for the last 13 years. Either I have been restrained by the tribunal or by courts. Now today, after I have issued the new rule and I called for the Havildars to whoever is applied,
607, 608 applicants are there. Now tomorrow this 608 will again come and say that we were not heard. Well, where am I left? I ask myself this question, and kindly see, minutes. I have given a comparative chart.
If they had any interest in the earlier proceedings,
My lord,
we definitely take this as a good point.
the same way not come, the subsequent people will come and say, we don't know what's going to happen. Now, kindly see one chart I've given.
No, these learned state council, yes, what learned state council is taking now that plea has been already advanced by Mr. Patnaik.
Yes.
That says there should not, that we are waiting, our merit should be adjusted and it should be.
But he is on the 30%.
Yes.
Now, after the new rules, 607 persons have applied.
Yes.
Now, kindly see the rule. I've just given a comparative chart. Let's see a comparative chart, my lords. Earlier,
have you filed that chart?
I have just handed over the chart. And a one-page chart.
Okay.
Yes. My lord, we are now looking at a 2007 pre-qualification test, correct, my lords? In the meantime, 15 years have lapsed. 15 years have lapsed in the meanwhile.
Lord General, that this is according to my assessment,
my lord,
only 2 points are very pertinent now.
My lord.
Whether being in the panel, these persons had any vested right to get appointment.
Grateful.
The subsequent 2023 decision is there.
Lordship,
that is the decision of the Supreme Court. Secondly, that you have to explain how 107 people in 2011 was appointed.
My lord.
If your own notification 3 years cap was applicable.
Correct.
That is one explanation.
Yes.
I do not know that gives them the any.
The lordships have dealt with that in the judgment.
The doctrine of negative equality, you are all aware.
Absolutely.
So that is an issue because how you have done.
Correct. Correct.
Then your own circular says
My lord.
that it says until the entire list is exhausted.
My lord.
Whether that expression
yes,
give them any right that we can wait, not only a question of legitimate expectation, it is a question of legitimacy of the panel that it will continue until it is exhausted.
But I said,
yes,
the panel will be for 3 years.
Yes.
But right, wrong, if somebody is questioning that, then the entire advertisement was wrong.
Yes.
So whoever has been appointed goes, who have not been appointed goes. So that is neither here nor there.
That is also not their prayer.
Yes. So therefore, my lord, if originally I couldn't have stipulated 1 year, 3 years, then everything goes. But then nobody gets any relief. The second submission to your lordship is, my lord, about 28 people have been appointed after the 3 years. 18 people have been appointed
18 people.
after the expiry of 3 years.
2011, I think. 107 plus 18. 107
Please
plus 18.
understand. My lords asked me, after 3 years were over, how many people have been
107 plus 18.
So 107 is also after 3 years.
Yes. Yes, please don't. No. Sir, 107 have been appointed and continued. The expiry date is 37, 16, 10, 2077. Look to the lecture. Actual version of the wrong.
Have you supplied that you did?
Yes, sir. I'll give the lecture, sir.
They have also supplied it.
There is no dispute over this, sir.
What is no dispute means when you say and I don't it's a dispute, Mr. Raj, right? The English is this. There is no dispute when both of us agree. Yes, you see, my officer is standing behind me. He says 18. You are saying 107 plus 18.
Sir, I'm looking to the maximum of the sir.
Supplied this date.
My lord, if your lordship sees, my lords, the select list was published on 16/10/2007. I hope your lordships have that.
Yes, yes.
And that is known as select list 2007. So your lordship will take it, my lords, and I will file an affidavit. I have asked them to do that. that from 16/10/2007 till completion of 3 years.
Just for a moment, sir. Sir, you yourself have prepared a date chart and supplied to us a copy. Where you yourself have accepted this.
Mr. Rathore, allow me to.
I don't. You finish.
My date chart doesn't change the factual position. So my instructions are 16/10/2007, the select list was made. It was valid for 12 years. Admittedly, nobody challenges it. And my instructions are, that 18 people have been appointed after 3 years are over. I will check on this. I will check on this.
There may be some mistake.
I will check on this. Mr. Rathore, right? What Mr. Mubili says, there is something there. So therefore,
no, in your date charge also this
correct.
21/10/2010 is there.
So my submission to your lordship is this. My first submission is, Milord, my first, I'm sorry. Milord, therefore, my first submission to your lordship was, milords, that they were never parties to the proceeding before the tribunal, nor before your lordship's court. 1. 2. I am squarely covered by the judgments of the Supreme Court, which says that all vacancies are to be filled up as per the prevailing laws. 3, milords, once the 2021 rules were framed,
yes,
the select list becomes inoperant. This is something I would want your lordships to consider. Assume there was a select list and 2021 rule comes, 2021 rules comes. So that ceases to operate because now the select list has to be prepared for filling up the vacancies
under the new
rules. And 4th, milords, that after this 18/9/2021, after the rules have been framed, 608 Havildars, leading firemen and firemen have expressed their willingness to participate for the vacancies under the new rules. So my submission is this, therefore, I have not made any promotions for 13 years. I don't want to be stuck for another 30.
Okay.
Grateful to you. And I will file a small 18, I will file a short affidavit, but I don't want to take a figure rather than 18 or 118 for the present.
I will expect that with the affidavit you file the order of promotion.
I will do that. I will do that.
Well, just for a moment, because I'll take only 2 minutes.
Yes.
So turn to page 33, annexure 6.
That we are taking on.
I think you are also discussing. That is dated 21/10/2010. That is that beyond 3 years. So
But
now
read that.
Yes, sir. Director of Fire Service, the Central Selection Board on 12/10/2010 selected the following fireman, moving fireman, driver, havildar for promotion to the rank of Assistant Station Officer in Orissa Fire Service. The Deputy Orissa Fire Service Training Institute also for undergoing the Orissa course training by fire officers Orissa Cuttack in consultation with the principal of Science of Orissa. Soon after the slots are open in their future. The final examination of the Orissa course of training should be sent to the director for fixation of their interseniority in the rank of ASO. On successful completion of training, they shall be allowed to hold the higher post on promotion. This is on 21/10/2010. Also look to that 107. Total number of persons 107.
Yes.
And admittedly, there is no dispute on 16/10/2007. The law advocate will say that there is dispute, there are nothing to say. On 16/10/2007, admittedly the select list was prepared. And this is 21/10, beyond 3 years. Now, I have to reply to the law advocate general submission so far the new rule is concerned. You also kindly look. He argued that 13 years we should not be able to fill up the post. But my argument was yesterday while I was advancing on behalf of the petitioners. In fact, after 2017, came into force in 2021, there is no fresh select list. That list was operating, and on the basis of that select list, they are giving appointment. There is no dispute. And so far, the interim order by says that is there any interim order by the tribunal for which you have not prepared a fresh select list? That is nobody's case. But the writ application was filed before RCB in 2019. And while the writ application was pending, the RCB issued notice while the matter was subject to this in 2021 that prepared they say all the judgments which have been cited, those are all the vacancies prior to the rule coming to court, that is for the purpose of recruitment. So this is a list, this is a select list prepared for the post of promotional, departmental promotion. And departmental initial entire place before the tribunal and before this honorable court is that till it is adjusted, we will give appointment.
There is a difference. In this Nikhil Ranjan Chakraborty's case, it was all the promotion vacancies. Yes. It is not the direct recruit post.
Sure.
The issue is something different, I think. You may perhaps argue that since I filed the writ petition in 2009, in view of the 1976 Supreme Court, what will be the relevant date on the basis of which the relief can be granted?
Sir, I'm obliged to answer. That is exactly what I was driving to that point.
Yes.
If my cause of action in the year 2019 and the judgment which was passed in 2017 was the subject matter of dispute in that writ application. Now, if the judgment will be delivered, that will relate back to that date. Now, because you have prepared a rule in 2021, that is not taken away by right party, and have said that whatever right I have on the list of that select list.
And now I have one question, sir. That is the last question perhaps I will be put to you. That the 2007, the pre-qualification results, you have distinguished yesterday, also day before.
Sir.
But there is a distinction between the selection and the result of the pre-qualification test. And whatever you argue, select panel cannot be on the basis of the pre-qualification test. Right? Yes. It will be decided whether they are selected or not by a separate board.
Yes, sir.
Selection.
Right,
yes,
selection board.
Yes, sir.
You were never selected by the selection board.
Yes, sir. You are subject to the PMRs. That's provision of 660.
No. Show us the document that you are selected by any time by the selection committee.
Sir, you are subject to that provisions. I think nobody was aware that
we are many of our 38 of us.
You also most
selected. Sent to training,
sir, 34%
examination, qualified there.
That is the pre-qualification.
Pre-qualification, after pre-qualification, a list prepared which is now exist or not. From out of that list, persons are time to time, this 107, these people were being considered by the selection board and selected and sent for training, and on successful completion training, they have been appointed.
Exactly.
So all that after 3 years.
You had argued yourself that is the qualification list. Not the selection. After that, they have been selected.
Same vote or not?
I was asking Mr. Mahanti also. Mr. Mahanti is appearing for some out of some candidate of 34. 34 candidates include so my 5 candidates, they have already completed the course of training. Not only selected, they have already completed. But Mr. Mahanti cases that 660 saying that the select list has to be prepared, and that on the basis of that select list, they have to undergo the training, the 4 months training.
In fact, my lord, I have borrowed these 3 words from the new rule. One is they're eligible to go for the departmental examination, another on qualifying the departmental examination, another select list. So that is why I use these 3 words borrowing from the new rules. Actually, this police manual says that select list.
Select list. Okay. That is why. You are also right to that question because Mr. Mahanti's argument, I was also confused, but I found that he is attending for both sides. So that is
at about 21 candidates are in these petitions before your lordship. They are yet to go for training. Only this much. That's the distinction.
So this is our argument. Only this.
When you going to file the affidavit?
Not 2 days.
2 days?
Monday?
23rd. You are fixing on 23rd.
My lord, 23rd, your lordships have fixed one matter of Mr. Rautra today at 2 p.m. That GIA.
You are only going to file an affidavit only.
I am going to answer to that. He's completed his argument. I am fine. No, so if that can be shifted to 24th, I have not issued. So that is the understanding. We will do this case on 23rd.
That has been fixed to 22nd.
Oh, that's all right. Then that's all right.
That is on 22nd.
We will do 22nd, 23rd, no problem.
Will worship again will advance our argument or
it's over.
That's it.
It's over. Only they will file an affidavit clarifying that. Yes.
But their own rate chart gives no to it.
That is why they want to re-verify their own statement.
Yes, yes.
That is the purpose of the affidavit.
Right.
Because you know the date chart is no document to rely to. This is only the convenience chart.
So that is why I have shown that symmetry
Really well of factual, only factual clarification. You can see the cause list on the last matter. WPC 33992 of 2021. This petitioner stands on a different footing with that of the other petitioner because this petitioner was never sent for training.
Qualified but never.
But never sent for training. But all the other petitioners, they were sent for training along with this.
You also clarified. Mr. Mohanty has been categorically stated unless someone is selected, he is not sent for training.
He has not been sent for training.
No, one set may be there, but the larger section is they are sent for training according to.
Once I am qualified, I got a.
No, they were not sent for training.
Yes. You have a vested right to be considered. That right of mine has been affected behind my back in the earlier judgment. That is what I am driving at.
If you can like to give bullet point arguments, that can you also by the next date you can prepare. Because there is one lead petition, as Mr. Mudoli is pointing out, that also struck our mind. That how these things can be taken up together, because we have to deal that with petition separately. So you pointed out, because as you are showing out that they were selected but not sent for training. Others are those who are selected and sent for training. Later on, they are not given the appointment. These are two sets of
yes. 34 stands on a different footing altogether.
Yes, just a bullet point these things.
Rightly, yesterday remarked that out of 34, how many persons are before us?
Yes.
That is also.
This Rohit Kumar Naik was not in the within 34.
That you are pointing out now. Thank you for that. Yes. And Mr. Mudoli just give also a bullet point argument, because I think Mr. Porija has taken up only the questions. This is a very pertinent. Maybe the factually some differences are there. But maybe
3 page note we will give you a lot. 3 to 4 pages. Not more than.
Of the next matter. List the matter.
The ling of my argument was existence of a right assigned to unknown. I had a right to be considered. That aspect has been taken away behind my back.
No, I think
47. 47. Please, my lords. The entire gamut of dispute between the parties is that, my lords, whether the appellant or, my lords, the respondent number 4 is a resident of an area called Dudki Dadar, so as to get an appointment in Dudki Dadar Anganwadi Center. And before taking, my lords, to different previous writ applications,
I'll just briefly assist this court by outlining the factual aspect. Yes, Your Honor, my lords, respondent number 4 was initially appointed as the Anganwadi worker.
Yes.
Appellant challenged her appointment and eventually challenged her issuance of residential certificate in her favor on the ground that she has obtained an incorrect residential certificate so as to get an appointment. Appellant was successful. After appellant was successful and when the learned sub-collector cancelled the residential certificate issued in favor of the respondent number 4, the concerned authority formally issued an order cancelling the residence certificate. Still, respondent number 4 was continuing in the said post. Appellant preferred a writ application before this honorable court. This honorable court was pleased to hold that since the residential certificate of respondent number 4 has been cancelled and the petitioner was the next best candidate available at the relevant point of time, the present appellant should have been issued with a fresh appointment letter and necessary direction was given to the competent authority to do so. Yes. At the same time, the respondent number 4 filed another writ application challenging the cancellation order on the ground that the action by the appellant to initiate a proceeding to cancel her residence certificate is barred by limitation. This honorable court was pleased to dispose of that writ application, remanding back the matter for fresh hearing before the learned sub-collector.
Yes.
The learned sub-collector conducted fresh hearing, received relevant documents from both the sides, and confirmed its previous order, holding that the residential certificate in favor of has been rightly cancelled. At this juncture, respondent number 4 moved to application. One, writ appeal challenging the order of the Honorable Single Judge, wherein direction was given to appoint the appellant as the candidate. The second writ application was challenging the second order after remand, wherein the first order was confirmed. Well, the submission of the present appellant before this honorable court is that in the second writ application that was preferred by the respondent number 4, wherein the second confirmation order was challenged, the fact that one writ application has been filed wherein the original cancellation has been confirmed, appointment has been given to the appellant, and the writ appeal wherein the respondent number 4 was again unsuccessful was not brought to the notice. In that second writ application's order is impugned before my lords right now. Humble submission of the appellant is that,
well, according to you, that the same issue earlier raised by filing a writ petition, and that was also went in favor of the present appellant
in writ appeal.
In writ appeal that was confirmed.
My lords.
But that fact was suppressed in the present petition and order has been passed by the single judge.
Grateful, my lords. That is the humble submission of the appellant, along with the fact that, my lords, that after being unsuccessful before the Honorable Single Judge and in the writ appeal, the question of reopening of whether the residential certificate should have been cancelled in favor of respondent number 4 or not is no more in question. The humble submission of the appellant is that for respondent number 4 to open the issue of cancellation should have challenged the order of the Honorable Division Bench. I'll manage take to three for orders. My lords may kindly open page 32 of my appeal memorandum. But that is the first original order wherein the learned sub-collector has cancelled the residential certificate
of yours.
My lords, page 32, annexure 5 of my appeal memorandum.
Yes.
The relevant page is, my lords, at annexure, at page 36.
Only this part, findings part, you should read.
My lords, from point 6, that's one prequel to point 6, means one statement prequel to point 6 is that, but this finding, the entire contention of the appellant was that after the respondent number 4 got married, she moved to another village and no more is a resident of the concerned Anganwadi center against which the advertisement has been issued. Now, my lords, and point number 6, I'll just place before this court. That's point 6. It is a fact Dhanmati Naik, who is the respondent number 4, is married to Khirasagar Naik of village Bhainsadhara. Point number 7. Khirasagar Naik is a resident of Bhainsadhara. It is a fact that name of Dhanmati Naik is mentioned in the voter list of the year 2004, 2005, 2006, 2008, 2007. Point number 9. It is a fact the name of Khirasagar Naik, husband of Dhanmati Naik, is mentioned in voter list bearing serial number so and so in 2001, 2004, 2005, 2006, 2007, and 2008. My lords, may turn on to next page.
Yes.
It's a fact that CDPO Jharkhand has supplied information under RTA Act to one Akshay Kumara video letter dated 17/9/2012 regarding birth, immunization, and survey report and family members of Khirasagar Naik of village Bhainsadhara. It is a fact that medical officer CHC has supplied information to Akshay Kumara regarding birth and survey report of Dhanmati Naik, wife of Khirasagar Naik, village Bhainsadhara from year 2001 to 2005. But the advertisement was issued in year 2005. What's the order? What's order on the second paragraph? The order passed on 6/5/2005 by the learned additional Tahsildar Paikamara in miscase number 270 of 2005 is set aside and remanded the LCR to the court of Tahsildar and directed to conduct inquiry afresh and hear both parties and dispose of miscase within a period of 3 months. My lords, thereafter, my lords, at page 9, paragraph 13, I have stated, consequent to this, learned Tahsildar Paikamara Vide memo dated 6/4/2015 cancelled the residential certificate and directed the respondent number 4 to surrender the residential certificate within a period of 7 days thereafter. My lords, as things stood thus,
yes,
despite the residential certificate having cancelled, the respondent number 4 was still continuing in the post. The appellant approached the respondents to offer her an appointment letter. She was unsuccessful, moved this honorable court in WPC 10998 of 15 minutes. My lords, the order of the said writ application is at page 38. But I'm so sorry, my lords, at page 40.
Yes.
But the relevant page is at page 44. There's a finding of the learned single judge, honorable single judge. And my lords, at para 6, did my lords find it?
Yes.
My lords, at para 6, considering the submission of the learned counsel for the petitioner that the petitioner was the only left out candidate available for consideration and looking to the document at annexure C3 to counter of OP3, this court finds there is already an assessment involving the case of the petitioner as well as OP4, and it appears the petitioner is the only other qualified candidate available for consideration. Therefore, this court, while allowing the writ petition, directs OP3, the CDPO Padampu, to issue necessary appointment letter in favor of the petitioner by taking action as appropriate, preferably within a period of 1 month from the date of communication. My lords, annexure 8 is the appointment letter consequent to the order of this honorable court. Yes. Annexure 8, page 45, page 46 is the English translated copy, which is dated 22nd of June 2019. My lords, from that date, the petitioner, the appellant has been working as Anganwadi worker, and my lords, this honorable court in this writ appeal has been pleased to protect her service. As on date also, she is discharging her duty as Anganwadi worker. My lords, as things stood thus.
What is the writ appellate order?
My lords, if my lords may permit, before me going to the writ appellate order, my lords, can I show 2 other orders, my lords?
What other orders show?
My lords, as stated earlier, my lords, challenging the cancellation order when the respondent number 4 moved this honorable court was pleased to remand back. Once I'll show the second order. My lords would find that order at page 47, annexure 9. My lords, the relevant ordering portion, my lords would find at page 52 of the same annexure, annexure 9.
Yeah.
Yes. My lords, it says, in view of the above analysis and interpretation, I am inclined to pass order that this court has not committed any mistake while passing the order condoning delay in filing the appeal. Hence, the final order dated 3/1/15 3/1/15 is the original order cancelling the residence certificate in favor of respondent number 4. In this appeal case is uphold. That is the wording, my lord. My lord, as things that they are, my lords, now annexure 7, which my lords saw earlier, wherein I have been given the appointment, my lords, this order where the earlier order has been upheld. Now, my lords, 2 applications were preferred. Challenging annexure 7, writ appeal was preferred by the respondent number 4, and the relevant order is at, my lords, page 53, annexure 10.
Yes.
Page 58, my lords, is the ordering portion wherein this honorable division bench holds that no order of stay has been granted. So at present, as matter stands, there is no certificate in favor of the appellant showing her to be the resident of Dudki Dadar, and we come to the conclusion that the order passed by the learned single judge is correct and has been delivered in its proper perspective, which requires no interference. Challenging annexure 9, my lords, which my lords earlier saw, wherein the limitation was condoned and the earlier order has been upheld, the impugned writ application was filed. Lords, my humble submission is that in the impugned writ application, which my lords would see in the reference cause title, neither the previous writ application under annexure 7 nor writ appeal under annexure 10 has been mentioned. My lords, annexure 11 is the impugned order, page 60. That is WPC number 7035 of 18.
Page
60, my lords.
60.
My lords, 60, annexure 11. Well, it's the honorable single judge, my lords, at page 63, my lords. At para 5, observes that submissions made by Mr. Rath are accepted. Aggrieved persons referred to in Rule 8 can only be an unsuccessful applicant under Rule 6. In such view of things, it is not necessary to adjudicate on limitation, impugned order set aside and quashed. My lords, my humble submission is that, my lords, in the noting of this writ appeal, WPC 7035 of 18 has been tagged. If my lords would see the reference cause title of 7035.
Just for a purpose of this sequence of the events,
my lords,
that after your writ petition was allowed,
first writ
in the first way they have this was challenged in the writ appellate division, and the appeal was dismissed.
My lords.
Whether in the meanwhile that matter was in the respondent number 4's writ petition, sequence of the dates I'm just talking about.
My lords, if I may tell the dates, my lords. My lords,
that when that writ petition was filed and disposed of.
My lords, writ appeal, my lords.
No, writ petition.
My lords, the impugned writ petition
by respondent number 4.
My lords, the impugned writ petition was filed on 24/4/2018.
No, there is an earlier writ petition also by respondent number 4.
My lords, that was
they're challenging the appellate order.
My lords, that order, my lords would find that is 11413 of 2015. That was the first writ application by the respondent number 4 challenging the cancellation. That is at page 38. It's WPC 11413 of 2015.
Okay.
Annexure 6, page 38. That was disposed of on 3rd of August 2016.
And you had not also challenged this order.
Well, my lords,
you means appellate.
Appellate has not challenged this order because, my lords, at the same time, my lords, when the matter went back, my lords, appellant fairly contested in the remand.
I am not questioning. I am questioning whether have you challenged the
No, my lords. Appellant has not challenged.
All right. So appellate in terms of this order participated.
My lords. My lords.
Can he now take this position that the subsequent writ appeal, because writ appeal was a subsequent to this part?
Lords, if I may clarify, writ appeal was not to this writ application.
No, I understand.
My lords.
I understand. That is why I am pointing to you this. You just give us a chronological chart of these things.
My lords. My lords.
Today, I will hear it tomorrow again. Come back with the chronological chart of the things.
My lords.
It is a little confusing because you are not challenging this, because by this your earlier order that was confirming your this residency has been disturbed by the single judge and said it should be reheard and entered. Then your residency was differently decided.
My lords,
Am I correct?
My lords, residency of R4 was in question.
Not yours.
No, my lords. Appellant has been challenging this respondent number 4's certificate.
Okay, that is why it is a little confusion.
My lords.
R4 residency was confirmed, and this is the writ petition by R4.
My lords, this present writ application.
No. That page we are on.
Page 38.
This is a writ petition by the R4.
My lords, R4.
So it says that this earlier decision was bad.
My lords.
Right.
My lords. But eventually, my lords, I participated. I was again successful.
You are again successful.
My lords. Again successful.
You just give a short night tomorrow.
My lords,
are you appearing in this matter?
For a respondent for my whole submission, my lord. The application was filed by the appellant challenging the initial selection for HON'BLE. The writ application was dismissed on the ground that since my residence certificate is valid, you cannot challenge my selection of HON'BLE. Matter was and direction was given. You approach the authority concerned. He approached the authority concerned. Authority rejected his claim, her claim. He again challenged the order of rejection before this honorable court, and this honorable court passed an order. Since his residence certificate is a proper certificate, his selection is valid. Again, the application was disposed of. Then, and a liberty was obtained, rather given by this honorable court. You can approach the appropriate authority if you so like. He filed an appeal in 2013, challenging my residence certificate after 7 years of granted certificate of 2005, and my certificate was cancelled. I challenged the cancellation of certificate before this honorable court. Since that limitation part and the jurisdiction of the appellant to challenge my certificate was not properly considered, this honorable court remanded the matter to the concern for the reconsideration of the cancellation of the certificate. That was again rejected, which was challenged in the before the honorable single judge, and which was set aside, which is impugned before this honorable court. And if my lord kindly see the order of this honorable single judge, page 60. The only question honorable single judge considered, only one point, my lord, page 62, kindly see, my lord. May.
Yes.
Page 62. The Mr. advocate appeared on behalf of petitioner and submits his client had obtained residence certificate. After 8 years of issuance, private opposite partner filed purported appeal. Order was made on the appeal, challenging which his client had filed WPC number so and so. By order dated 30th November 2014, the appeal was remanded. Impugned herein, the order dated 23rd June 17 made by sub-collector on remand. It submits Orissa Miscellaneous Certificate Rule 84 are applicable. Rule 6 provides for orders on application for certificate. Sub-rule 2 says, if the revenue officer is of the view that the certificate may not be granted, he shall pass necessary orders
in the case record, briefly recording the reason thereof. Rule 8 provides for appeal. Only person who can be aggrieved in an unsuccessful applicant. Private opposite party number 5 is an outsider to the proceeding initiated by his client's application for residence certificate and granted long before the appeal was filed. The appeal was also hopelessly barred by time. In these circumstances, impugn order dated 23rd June 17 is set aside and quashed. And there are submission of the state government and submission and record was verified and para 5. Submission by Mr. Ratho was accepted. Aggrieved person referred in Rule 8 can only be unsuccessful applicant under Rule 6. In such view of things, it is not necessary to adjudicate on limitation argued on by Mr. Ratho. Now I will consider the rule. Last episode I have given a photocopy of the 1984 rules.
Yes.
Now I can see the Rule 6. Before that, Rule 4. That is application for miscellaneous certificate, and Rule 6 kindly see. Orders on the application.
Yes.
Rule 6. Orders on the application. 1. If on the basis of document, records, and the result of the inquiry, if any, the revenue officer is of the view that the certificate applied for may be granted, he shall pass necessary orders in the case record and sign the appropriate certificate specifying the purpose solely for which it has been granted. The certificate shall be handed over to the applicant or his duly authorized agent on due acknowledgement of receipt. 2. If the revenue officer is of the view that the certificate applied for may not be granted, he shall pass orders in the case record, briefly recording the reason thereof. Now I will answer Rule 8, appeal.
Yes.
Any person aggrieved by an order passed by the revenue officer under Rule 6 may prefer an appeal before the forum they are given, my lord. Can you see the proviso? Provided that no appeal under these rules shall be entertained unless it is preferred within a period of 3 months from the date of the said order. The submission of the respondent for the honorable single judge was, my lord. If a person applied for a residence certificate and document was verified with competent authority and comes to a conclusion it is in order, certificate is to be granted. And in otherwise, if certificate will be rejected, the person who applied, he can file within a period specified before the authority concerned in Rule 8 by way of an appeal. And that by considering this, honorable single judge passed an order without entering into the other aspect.
Your Lordship, I also see Rule 7.
That was also direction of the honorable court. That was the submission para 3 in the impugn order. This is submission of the honorable state council before the honorable single judge. And the honorable court also para 6 impugn order set aside, concerned authority is left to act in accordance with law. Last paragraph of the
last line. So tomorrow, just Colonel, this is that we are not confused in any points. Because you have raised a one point, that is why this chronological sequence is required. You says because the order of the writ appeal, the issue is finally settled. The order passed by the learned single judge ought not to have been passed because this issue he cannot touch because it is by a superior forum, it has already been settled.
Assistant Justice Court, I'll prepare a chronological sequence of writ applications.
All right. Tomorrow, can you give it tomorrow? Yes.
That is with regard to selection of Anganwadi worker, my lord. Where writ appeal was dismissed, since the honorable division bench said, since you lost your certificate has been cancelled, now you cannot. You have to the order of dismissal will stand.
All right. All right, supply a copy beforehand so that he can, Mr. Ratho also can make his submission. All right.
It's very grateful, Manoj.
Tomorrow.
Call the matches.
Item 32.
Well, you are Mr. Shamojyoti Raut.
My lord, Swayamjit Raut. Swayamjit Raut, my lord.
Swayamjit.
My lord.
But Mr. S. Raut, the upper limit. But we have heard Mr. D.N. Raut and counsel appearing to the responding of 4 in full. Mr. Kuntia, we'll hear you tomorrow.
Yes, ma'am.
Mr. N.K. Kuntia, an additional government.
Item 47, my lord.
Three.
Mr. Arnab there.
I'm there in 47.
Yes.
State does not have much of a role, your lord. Pro forma.
Come tomorrow then.
32. May it please, your lord. The respondent is a teacher in a non-government aided educational institution.
Yes.
She claimed the benefit of granting aid order 1994.
Yes.
She filed a case before the State Education Tribunal in 2008. And in 2012, the tribunal was pleased to pass an order that she was eligible to receive granting aid under the 1994 order and ordered so. The issue before your lordships is whether the respondent is entitled to arrears with effect from 1994 or only the arrears are to be restricted for a period of 3 years prior to the date of filing of the tribunal case in light of the judgment of the Honorable Supreme Court in Tarsam Singh. That is the short issue that your lordships have to decide. If your lordship may kindly have page 23, this is the order of the tribunal. Page 23. Your lordships have page 23?
Yes.
I'll read the judgment. The applicant in this present application under section 24B of the Odisha Education Act makes a prayer for a direction to the opposite party number 1 for release of granting aid in her favor in accordance with the provisions of granting aid order 1994. The case of the applicant as delineated from the application runs thus. The applicant has been working as the third post of lecturer in history, which is an aided education institution within the meaning of section 3B of the Odisha Education Act. It has been averred that keeping in view the prevalent yardstick, the governing body of the college resolved to fill up the third post of lecturer in history, and accordingly proposal was submitted to the opposite party number 2 for creation of such a post, and the latter also approved the third post of lecturer in history with effect from 23/6/89 under Annexure 1. Your lordship may skip over to paragraph 3 and 4. Paragraph 3, it states that we had not filed any counter affidavit. Paragraph 4. In absence of any factual denial, all the averments made by the applicant in the GI application are deemed to have been admitted. It is accordingly held that the applicant was appointed against the third post of lecturer in history on the vacancy of her immediate predecessor, and the third post was created in view of the prevailing yardstick, and such third post was approved with effect from 23/6/89 under Annexure 1. It is also to be held that the applicant joined on 17/8/93 and thereafter the proposal was sent to approve her appointment under Annexure 3, where Annexure 3 discloses the date of eligibility of the applicant to receive granting aid much prior to coming into force of the granting aid order of 1994. I do not find any reason as to why the opposite party number 2 passed the order dated 10th August 2011 under Annexure 4 series to release block grant in favor of the applicant in terms of granting aid order 2009. Once the college becomes an aided education institution within the meaning of section 3B of the Odisha Education Act, and the applicant comes within the fold of the granting aid order 1994, having been appointed against the approved post prior to 1994, there is no reason to deprive the applicant from getting the financial benefit in terms of the granting aid order 94. Now the operative part. It is accordingly ordered that the opposite party number 1 and 2 are directed to approve the appointment of the applicant with effect from the date of her joining, and to release granting aid in favor of the applicant strictly in accordance with granting aid order 1994, along with the differential salary components within a period of 4 months. But we had preferred an appeal against this order. that was dismissed on the ground of delay and laches. Your Lordship will find the appeal at page 29, the appeal order. My submission, Your Lordship, to Your Lordships is that the tribunal, while holding that the respondent was entitled to the relief to the benefit of granting aid order 1994, did not consider the issue or pass any direction as to the date from which the granting aid was to be released. Your Lordship may kindly see page 30, Annexure 3 series.
Page
30. This is the order that was under challenge before the writ petition.
Yes.
We have granted him the relief of granting it order 1984, but if Your Lordship may see para 3, the respondent was agreed by paragraph 3. Arrear claim as admissible to the incumbent may be calculated as per actual differential by deducting the salary released by the incumbent from the government. The arrear claim shall be restricted to only 3 years before date of filing of the present petition, as per the judgment rendered by the Honorable Apex Court in Union of India versus Tarsim Singh, and to be paid to the incumbent subject to the provision under section 7C of the Odisha Education Act. The Director of Higher Education will be responsible for scrutinizing the records of the college with regard to the claim decided in favor of the petitioner. Payment of arrears is subject to concurrence of the Finance Department.
All right, you are just importing the Tarsim Singh principle.
Your Lordship.
Tell us which date will be taken as the date of institution.
The date of institution of the petition will be the tribunal petition. 3 years. He is entitled to the relief of arrears.
Tribunal petition was instituted.
Tribunal petition was instituted in 2011, Your Lordship. It's case number 489 of 2011. So he will be entitled to relief with effect from 2008. The rest has to be treated as notional.
All right.
But I'm handing over a copy of the judgments of the Supreme Court in Tarsim Singh.
That has been followed in the actual decision also, State of Madhya Pradesh versus Jogendra Srivastava.
Actually, pleases.
That was a recent decision on the basis of Tarsim Singh.
And my lord, granting aid is not a vested right. In 2019, Anup Kumar Senapati, the Honorable Supreme Court, has said that there is no vested right for any institution to receive granting aid. In fact, it was dealing with situations which were identical to the respondent here, who had approached the tribunals after more than 15 years delay. I will only show Your Lordships a copy of the judgment in Anup Kumar Senapati.
You give that copy. What's Senapati is 2009, no?
No. What that?
Yeah, it's in there.
I forget.
So 19.
Your Lordship will have page 634. The judgment starts at page 634. The question involved in these appeals is whether the employees are entitled to claim granting aid as admissible under the Non-Government Aided Colleges Granting Aid Order 1994 after its repeal in the year 2004 by virtue of provisions contained in the Odisha Granting Aid Order 2004. The 2004 order has also been repealed by the Granting Aid Order 2008. At paragraph 2, they have quoted section 7C. This is very important, Your Lordship. Section 7C1, Your Lordship has page 635. The state government shall, within the limits of its economic capacity, set apart a sum of money annually for being given as granting aid to private education institutions in the state. Then Your Lordship may kindly have paragraph 26 at page 648. The Supreme Court captured these situations where teachers had approached with enormous delay. Page 26. Sorry, para 26, page 648. Your Lordships have it? The employees have filed representations to claim granting aid under 1994 order belatedly for the first time in 2011-12, and that too according to the directions of the Honorable High Court, which were rejected. Thereafter, they approached the tribunal by way of filing original applications, whereas on completion of the qualifying period, the institution has to inform the director to claim granting aid. there is no material on record that the institutions have duly applied in the particular academic year and within the time fixed for making application as per the 1984 order, and there is nothing on record indicating that the requisite information was furnished. No such supporting documents have been placed on record. Be that as it may, fact remains that there is no order placed on record whether such prayer, if any, made by the institution has been rejected as per the 1984 order. The representations which have been placed on record are of 2011-12, as the granting aid is annual, dependent upon the economic limits and financial viability of the state government. It was too late in the day to file original applications or writ petitions in the year 2011-12, claiming the benefit of granting aid under the 1984 order. In case the employees or institutions were desirous of obtaining granting aid under the 1984 order, they ought to have taken the steps within the reasonable time in view of the fact that it cannot be claimed as a matter of right, but it depends upon the annual budget and fulfillment of various factors as contained in the provisions of the 1984 order. Then your Lordship may kindly have paragraph 38. They discuss the question of repeal. At page 655.
Yes.
Page 655, paragraph 38. Thus, there was no vested, accrued, or absolute right to claim granting aid under the Act or the 1994 order. Merely fulfillment of the educational criteria and due appointment were not sufficient to claim granting aid. There are various other relevant aspects, fulfillment thereof and investigation into that was necessary. Merely by fulfillment of the one or two conditions, no right can be said to have accrued to obtain granting aid by the institutions concerning the post or individual. No right has been created in favor of the colleges individuals to claim the granting aid under the 1984 order after its repeal. No claim for investigation of right could have been resorted to after repeal of the 1984 order. But in the present case, the respondent already has an order in his favor from the tribunal. The FAO was also dismissed by this honorable court. Therefore, we are bound by the order of the tribunal. But the order of the tribunal has only said grant him GIA, the benefit of GIA order 1994, and we have granted that benefit. But the issue of arrears has not been decided. The date from which the arrear has to be granted, and therefore, in the limits of economic capacity of the state, the principle enunciated in Tarsim Singh should be applied to this case. That's my submission.
Here, my lord, my non-friend is arguing the writ appeal, challenging the order passed on single judge, but he has entirely relied the judgment passed to the tribunal, which has already been confirmed by the Supreme Court in the FAO. We have already been set at rest, and that after that, the order has been complied with. They have extended the benefit, fixed my entitlement, and granted the benefit. Only my lord, so far the area, they have restricted imposing that taxation. That is under challenge. I have challenged in the clause 3 in the report of single judge. Now the single judge, after hearing the parties and after going through the judgment passed by this Supreme Court in the division bench as well as other co-head bench, where the judgment passed in the taxation has been distinguished, and specifically in respect of aided colleges, that two judgments relied by the single judge while passing the present impugn order. That is also kindly see. Without referring and without arguing that impugn order.
Will continue tomorrow because I have a sitting
tomorrow. Maybe after long Friday, there is no code of single.
Tomorrow is a Friday, no? So 22nd. I will matter will be taken out on 22nd.
12:30 take only 5 minutes.
I cannot do that because a lot of matters are already fixed. I forgot that tomorrow is a Friday. So I will come on 22nd.
Project I also fix a time because
it will be taken up at 2 only. We are fixing at 2 only.
I may kindly be pardoned, my lord.
Yes.
The item 64 that could not be taken up today.
22nd, we are fixing your matter also.
2 p.m.
2 p.m.
Item 63, Lord. Item 63, Lord.
2 p.m.
Item 63, Lord. Item 63, Lord. That is the internet is there, Lord. But should we fix a date so the matter can come? Item 63.
Sometime in 18th of September, like that. 18th September, interim order was
Item 61, Lordship, any citations have to be taken on record, Lordship. 61.
Yesterday's matter.
Yesterday, Lordship.
All right.
Item 51. Lordship 35, Lordship passover matter.
Just.
Monday was Monday.
Because item 63, no?
In this chance, Monday matters.
Okay, to the
Nice.
At 22nd, my lord, that other matter, batch of matter also fixed at 2 p.m.
Which 27?
Repeal of the 2004 order where that is challenged.
The batch of ultra virus matter.
That's all right, but hardly now 5 minutes time in to you. You think that his argument, just the final point he has raised that tribunal did not decide the question of ADS. Right? If it is not decided, they have decided according to their wisdom. Right? And that has been challenged. Principal judge has passed the order. If they are agreed, they are coming to that. Give me your argument on this line only. Because if the tribunal was passing the area direction and it has been confirmed, that would be a different character. According to Mr. Dera, is that no decision regarding area and how the area will be paid.
Tribunal directed to release the grantee strictly in terms of grantee order 94 by approving his appointment with respect to his initial joining.
Right.
That is the finding. I'll place my.
All right. There is some decision of this court also, the division bench that says they pay the entire area also.
Exactly.
Let us see what happens. Item 50. Because the person principle is based on someone is approaching the court belated stage.
That is with regard to
principle of the money
claim for disability pension.
That the 3 years concept has been just developed and the money suit has to be filed within 3 years. And that was applied in a writ proceeding. We'll consider that this.
Item 51.
Entry 1 is there.
52, 53 and 54. The interim orders are there.
Just a list on 18th of September. Entry order is passed to reach and continue until further orders.
Item 35, Lordship, passed over matter. Item 35.
21st of August.
Lordship, 20 August. Lordship.
21st of August. This matter. Monday. Let us see what happens. Okay.
Time maybe. Anytime, Lordship. Can be.
This very 21st. There is a break bench is there. That is why I am not fixing the time at 2. You just mention on that day.
Last
time.
I'll mention.
And Mr. Behra, he has left the court. No. That you just the direction part of the tribunal judgment, then the judgment of the learned single judge, and the order that you have passed in the course of the implementation, this without any affidavit, just produced before us. All right. I think it is a part of the record.
Yes. It's part of the record.
Yes.
For orders, item number 1.
Beg apology, my lord. I am item number 1. I am present, my lord. My lord, may kindly fix up this date, this case on next week, my lord, because I am out of Cuttack and my file is not also with me, my lord.
All right. On 25th of August, List is taken on 25th of August at 4 p.m. But at the request of MS Lakshmi Sharma, Learned Counsel, appearing for the review petition.
Much obliged.
Oh.
For orders item number 1.
It's for restoration, not within time. I missed the list, my lord, therefore, my lord, I could not attend at the time of page. And 8/9/2022 dismissed, I have supplied the certified copy of that order, my lord, along with the memo.
Notice was issued earlier. So problem is that these private respondents of the opposite parties.
Earlier notice was not issued, but substitution notice.
The problem is this is on record now because of our this information system. I think in their absence you cannot do. What we can permit you.
Notice was not issued. They have not appeared in this.
So now in this petition they have to be given notice. That principle is what we follow in the civil suit, that if the notice is not of the defendant, whether this can be applied in a writ petition.
Writ petition, my lord.
Can be.
Writ appeal.
This is a writ appeal.
My lord.
It was not admitted, writ appeal.
Writ appeal has not been admitted.
So we are allowing it. Because they did not know also the existence of the writ appeal.
Yes.
So in the writ appeal, we will consider the admission, and if the notice to be issued, that can be done. Heard Mr. Sumitra Mohanty, Learned Counsel, appearing for the applicant. Also heard Mr. Arnav Behera, Learned Additional Standing Counsel, appearing for I think 22 only.
22.
Opposite party number 22. So it has been stated by Ms. Mohanty, Learned Counsel, that the writ appeal was not admitted when the impugned order Where is the order you have put? You filed the certified copy. When the impugned order dated 8/9/2022 was passed by dismissing the said appeal for non-prosecution. As such, opposite parties number 1 to 21 did not know the existence of the appeal also. So, Mr. Behera, however, has not opposed the prayer for restoration. Stop. It has been stated in this application for restoration that the petitioner/appellant had no knowledge of listing of the said case on the relevant day. Of non-attendance of the petitioner/appellant's counsel on the said day was not intentional or deliberate. The petitioner/appellant was prevented by the sufficient causes for non-appearances. Even though they say those causes are not disclosed in the petition, for the substantive rights of justice, we recall the order dated 8/9/2022 as delivered in WA number 5/10/2013 and restored the said writ appeal to its original file. In the result, this application stands allowed in the writ appeal. Raised this appeal on 1st of September 2023.
For place admission.
For admission, but we make it clear that if on that day there is no representation, we will be again compelled to pass an order for non-prosecution. All right, Mr. Vail.
Obliged.